Good afternoon, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Thank you. Good afternoon. And have you tested the equipment to see if Mr. Santiago can hear you?
Yes, Your Honor. The interpreter can confirm there is connection to the headsets.
Thank you. And sir, can you please state your name?
Ángel Santiago Chico.
Angel Santiago Chico.
Sir, you are here on numerous matters. Let me start with an arrest affidavit charging possession of cocaine with intent to sell or deliver as count one. Count two, possession of cocaine. Count three, possession of drug paraphernalia.
Your Honor, I apologize for interrupting. Because there are so many cases, can you give case numbers, please?
All right, thank you. No problem. So I'm addressing first 2022 CF 815480. And count number three was possession of drug paraphernalia. As I said, I reviewed the charging document, find probable cause. Count one, bond is set at 15, before I forget, on all of these matters, I am appointing the Office of the Public Defender to represent him at this time. Count one, bond is $15,000. Count two is $150. Count three is $100. Then I've got another charging affidavit, case number 2022 MM 4720, with the charge count one, possession of drug paraphernalia, count two, possession of cannabis over 20 grams. I've reviewed the charging document and I find probable cause. Bond on count one is $500. Bond on count two is $500.
Your Honor, on count, well, I don't know which one is count two, but the drug paraphernalia, I would ask that you set the bond at 100, only because I believe it's the same incident, and they've already charged him for the drug paraphernalia once, is my understanding. It's all the same incident, it's just they broke it up into different case numbers.
State.
He's asking you if you.
Oh, 713, 713. Yes, Your Honor, it does appear to be the same incident. It is the same incident. There's obviously going to be more than one drug paraphernalia, as there's more than one drug listed, but I have no objection to that.
All right, it's a reasonable request. So with regards to count one, in case number 2022 MM 4720, possession of drug paraphernalia, the bond amount will be reduced to $100. Then we're going to proceed to bear with me. It's all one case? Okay. Let's go forward with case number Are we in the same order here? Correct, the court case number, is that what you're gonna be reading? Do that, okay, so I'll refer to this as court case number 2100832 from Osceola County. I have a violation of probation with regards to let me put it this way. I have appointed the Office of the Public Defender to represent him on all matters. And I know that defense counsel here has always been prepared, and I know has reviewed files in advance. There are numerous numerous matters here with regards to out-of-county BOPs.
Yes, Your Honor.
Can I just read the case numbers?
Yes.
Refer to them in that manner? If you would be waiving the reading of all violations of probation, is that okay?
Yes, Your Honor.
Okay, and that would save some time. And for the record, even though it's Osceola County, I know that that is also the jurisdiction encompassed by the Office of this Public Defender as well. And so, sir, you've got, going back to court case number 2100832, a violation of probation. In that case, that is set at no bond. You have a violation of probation in court case number 2100835. That has also been set at a no bond status. You also have court case number 2100837 from Osceola County. That violation of probation is set at a no bond. With regards to court case number 2100926 from Osceola County, that is a violation of probation, also being set at a no bond status. Anything else from the state or defense?
Nothing, Your Honor.
Nothing from defense, Your Honor.
All right, thank you, sir. Do we have any other Spanish interpreter cases? Okay.
Sí.
Right, and sir, can you please state your full name?
Lázaro Mena Gamboa.
Lazaro Mena Gamboa.
Sir, you are here on a charge of aggravated battery with a deadly weapon. I'm appointing the Office of the Public Defender to represent you. I have reviewed the charging document and find probable cause. Bond is set at $3,500. State or defense?
Your Honor, I would ask that he have no contact with the victim or witness.
I'm going to require, sir, that you have no contact directly or indirectly with the alleged victim in this case or the witnesses to this case. Anything else?
No, Your Honor.
Nothing
Anything
from
else?
defense, Your
All
Honor.
right,
No.
thank you.
Thank you.
Do we have any other Spanish interpreter? All right, thank you.
Before I go, Your Honor, may I have this last defendant's case number?
2022 CF 8145.
Thank you very much. Thank you, Your Honor. Have a great day.
Thank you.
True.
Mm-hmm.
Please state your name.
No. Robert Crew.
Sir, you are here on a charge of trespass on property after warning. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you.
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit time served, no return to 9541 East Colonial Drive. Mr. Crew would like to accept the state's offer and enter a plea of no contest.
State, is that the offer?
Yes, Your Honor.
All right. Can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
And sir, can you please state your full legal name? Thank you.
Robert Clayton Crew Jr.
And let the record reflect that the plea form was signed in open court. And sir, that you review the plea form with your attorney.
You hear me?
Can you hear me okay?
It's kind of loud.
Okay, we'll wait a little bit.
Okay, now.
And sir, that you review this plea form with your attorney.
Yes.
You You understand the rights that appear on the front of the plea form.
Yes.
You understand you are giving up those rights by entering a plea here today.
Yes.
You understand the maximum and minimum penalties for the charge you are pleading here today on.
Yes.
Are you entering the plea of your own free will?
Yes.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly here today?
No.
Are you satisfied with the services of your attorney?
Yes.
With regards to the charge of trespass on property, after warning from an incident of July 13, 2022, how do you plead?
No contest.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for 2 days. Thank you. 2 days, time served. I'm going to require that you not return to the place where this incident took place, which is 9541 East Colonial Drive. I'm going to impose upon you all applicable court costs and fees and require that they be paid within a 1-year period. And sir, you have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir.
Thank you.
You put your hand down. Just stop right there.
Please state your name.
Lucinda Ellis.
You are here with regards to a warrant. I'm appointing the Office of the Public Defender to represent you. Defense counsel, do you waive the reading of the warrant?
Yes, Your Honor.
And this warrant was set at a no bond status. I will take comment from State or Defense with regards to that.
Your Honor, these generally do come in at no bond, but she is entitled to a bond.
Yes, Your Honor. I just
Right.
ask that you set a bond, Your Honor.
Yeah, any comments on that?
No, Your Honor.
No recommendations?
I generally do not, Your Honor. I can look at the bond schedule, but that's the only thing that I would do.
No, no, that's okay. I just like to give an opportunity because when I get this documentation, I don't always have all the background information.
And she doesn't have, other than that charge, Your Honor, she doesn't have much of a history, so I just ask that you consider that when setting the bond. I don't see any other, from the face sheet, I don't see any other violations.
Just to show you, the sheet that I get is rather limited in the information.
That's what I have as well,
Right.
which shows that she doesn't have any other violations. So I just ask that you consider that when setting the bond.
Mm-hmm. All right, and so I'm setting bond at $2,500 plus pretrial release.
Your Honor,
She's
she
not good.
Yes?
didn't qualify for pretrial.
Didn't qualify for,
No,
so
Your Honor.
can't put her on any type of supervision?
She's, if I may, Your Honor, she's
Yes.
already technically being supervised by the system with her reporting requirements. So I just,
Well, the allegation is she's
yeah,
not complying.
and it's in Florida because of the, it's very difficult with these type of charges, because it could be something as small as forgetting to change the driver's license. So I just ask that you consider that she will have to continue to comply with those reporting requirements, and she actually has to do it within 24 to 48 hours upon release anyway, Your Honor.
Okay. State, any comment?
No objection, Your Honor.
All right, and so bond is set at $2,500. You are to comply with the requirements of reporting. Please state your name.
Santana Melinda Shawan Daniels.
You're here with regards to charge of trespass on structure or conveyance. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Is this applicable?
It is,
It is, Your Honor. The offer was an adjudication of guilt, 3 days in Orange County Jail with any credit for time served, and no return to the College Park Tower.
and Your Honor, I have some concerns. I just ask that you set a bond.
Okay.
What? What? Bond for what? A what? A bond for what?
The charge, ma'am, is a trespass on structure or conveyance, and the bond on that is a $500 bond. I'm also going to require that you not return to the place where this incident took place. Okay?
Return what? I'm still in return. $500 bond. Okay, I'll sit on it like I do. All right, it's already paid. Thank you.
All right, thank you. Okay. Got 4. Okay. Please state your name.
Scott Stencil.
Sir, you're here with regards to charge of driving under the influence. You have the Office of the Public Defender representing you. Is there any comment at this time from the State or Defense?
No, Your Honor.
Wait, who is this?
Scott Stansel?
Oh, okay. Your Honor, I will enter a plea of, not guilty.
All right, thank you.
Division 83, pretrial conference, August 1st at 8:30, courtroom 6C.
August when?
I have it right here.
Okay.
Madam Clerk, that was Division 83?
Yes.
Okay, thank you.
Please state your name, sir.
Good afternoon, Your Honor.
Good afternoon. And your name, please?
Trinell Elijah Wine Anderson.
Thank you. And sir, you are represented by the Office of the Public Defender. You are here with regards to a charge of petty theft of $100 or more.
And Your Honor, we're going to enter a plea of not guilty.
All right,
Division 62, pretrial conference, August 8th at 8:30, courtroom 12C.
you don't need these.
I apologize. Can you give me the date again? I apologize.
Division 62, pretrial conference, August 8th at 8:30, courtroom 12C.
Thank you.
Yeah, I know. Yep. So I'm going to let them know, see if we can. If not, then you could just bond it. Like, someone else.
Have a nice day, Your Honor.
Thank you. Thank you very much, sir. You as well. Please state your name.
Luke Hans Charles.
And
I had Joshua Barnes is medical. This individual, Joshua Barnes, is represented by the Office of the Public Defender on a charge of trespass on property other than structure or conveyance.
I will waive and enter a plea of not guilty, Your Honor.
Division 62, August 8th at 8:30, courtroom 12C.
Please state your name, sir.
Luke Hans Charles.
Thank you. You are represented by the Office of the Public Defender on a charge of trespass in structure.
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit time served, no return to 5450 Point Vista Circle. And Mr. Charles would like to accept the state's offer and enter a plea of no contest.
And is that the offer state?
Yes, it is, Your Honor.
Is this the right amount? Thank you. Let the record reflect the plea form is being signed in open court. And sir, that you review the plea form with your attorney? Thank you.
Yes, sir.
And do you understand the rights that appear on the front of the plea form?
Yes, yes, sir.
You understand you are giving up those rights by entering a plea here today?
Yes, sir.
You understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No, sir.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No.
You understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
And are you presently under probation or parole for any other offense?
No, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of trespass in property from an incident of June 3rd, 2022, how do you plea?
No contest.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for 42 days, time served, Orange County Jail. I'm going to require that you not return to the place where this incident took place, which is 5450 Point Vista Circle. I'm going to impose upon you all applicable court costs and fees and require that they be paid within a 1-year period. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you, sir.
Thank you.
I know the state didn't file on it. I just want to make sure.
Oh, they'll take care of that.
Okay, he'll be fine. Okay, so you'll be released.
Thank you. Please state your name.
Hi, Abel.
Abel? All right. And you are here with regards to a charge of resisting officer without violence. I have reviewed the charging affidavit, and I find probable cause. Bond is set at $500.
And Your Honor,
Yes.
the offer from the state is a withhold and court cost. And Ms. Abel would like to accept and enter a plea of no contest. In exchange for the plea, Your Honor, I would ask that you take no action on the out on bonds. She has no history. She was in pretrial diversion. And I don't know what's going to happen. I'm pretty sure they're going to have to work that out, given that she picked up this charge, Your Honor.
State?
That is the honor, Your Honor. That is the offer, Your Honor. It is a withhold. And as the defendant is in pretrial diversion, I generally do not ask the court to do anything, as the state attorneys will decide what to do with regard to pretrial diversion.
But this is not an automatic situation where if she enters a plea of guilty or no contest, that it will kick her out of PTD.
No, Your Honor. If she was going to be, we had the discretion, Your Honor, that as soon as she was arrested, we could have kicked her out of pretrial diversion. So whether she enters the plea or not, it's just another factor to be taken into consideration.
Does this ever take a different route?
Depending on the person's record, what it is that they are charged with and their history, yes, Your Honor, all of that is taken into consideration.
And the only issue and concern, Your Honor, is that is her out on bonds, obviously.
A concern that I have, it's been explained to me that she's on PTD.
Correct.
And what I'm trying to understand in her particular case, is there anything that we do here that might affect, or what can we do to maximize her ability to stay in PTD?
So if Your Honor is not inclined to revoke her out on bonds, I would ask that you stay the bond and take no action on the out on bond. That way, maybe she can stay in pretrial diversion.
And the question, though, I guess is, I'm being made aware that there's a plea offer. It's obvious that this young lady is in custody and may be thinking that priority number one for her today is to get out of custody. And that might be making her or influencing her and making a decision to take this plea offer now.
That's correct, Your Honor.
And in the long run, entering a plea here today, and even if the court withholds, does it put her at a disadvantage with regards to possibly being considered to continue in PTD?
It may, Your Honor.
Yes, it
If-
may, Your Honor.
We're okay with you staying the bond if you do not revoke the out on bond, given she has no history, and she could see if pretrial diversion, if they'll work with her, if they're gonna kick her out. It was just her having to sit here, Your Honor. So we're okay with you staying the bond amount, if you take no action on the out on bond, and then she could see if pretrial diversion will work with her, given she has no other criminal history.
Right, is there any comment from the state?
State would have no objection to that, Your Honor.
Okay.
Okay.
And so at this point, I am, the bond on the resisting without violence is $500, and the court is taking no action with regards to her other two cases, which are 2021 CF 5605 AO, 2020 CF 14834. I'm not going to address those PT or out of, I'm not addressing those other cases. I'm not revoking anything at this time.
Thank you, Your Honor.
All right, thank you, Ms. Please state your name.
Roderick Bartha.
And sir, you're here with regards to two charges. Count one is possession of drug paraphernalia. Count two is trespass on property after warning. I have reviewed the charging affidavit and I find probable cause.
And Your Honor, the offer from the state is an adjudication of guilt. Credit time served, no return to 6115 South Orange Blossom Trail. And Mr. Bartha would like to accept and enter a plea of no contest. I believe he has a private for his out on bond, Your Honor.
I believe it's a PD, is according to this sheet.
I thought I saw Leon. Let me just double check.
The sheet I have is indicating a D. Ashley.
Let me just double check. Because when I looked, I wrote, maybe it's the wrong thing. Yeah, I see Cheek Leon. Oh, we withdrew on the 11th, Your Honor. He has,
As conflict counsel.
Leon Cheek, is he?
Yeah, I believe.
Yes,
Okay,
he's
so he's
regional
got
conflict.
conflict counsel,
Yes.
Attorney Cheek. Okay. All right, and is that the offer state?
Yes, Your Honor. Adjudication of guilt, credit time served, and no return to 6115 South Orange Blossom Trail.
All right, and has there been any understanding with regards to recommendation on his out-of-bond ROR? I mean, on his other case?
I would ask that you take no action, Your Honor, given that he is resolving the new law offense today, and both are nonviolent offenses. I believe based on the arrest affidavit, he was sleeping when the police arrived.
And so is the state taking a position on this?
Your Honor, I would have no objection to the court taking no action. It's a drug offense. The new case is a trespass, and he has next to no history. So I would have no objection to that, Your Honor.
Okay, thank you. And so let the record reflect the plea form was signed in open court. And can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
Can you please state your full name?
Roderick Savares Bartha.
And did you review the plea form with your attorney?
Yes.
Can you hear me okay? Can you hear me okay?
Yes.
All right, did you go over this plea form with your attorney?
Yes.
You understand the rights that appear on the front of the plea form?
I do.
Do Do you understand you are giving up those rights by entering a plea here today?
Yes.
Do you understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes.
Are you entering the plea of your own free will?
Yes.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
No.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly here today?
No.
Do you understand that entering a plea of guilty or no contest to these charges can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes.
Are you presently under any type of probation or parole for any other criminal matter?
No.
Are you satisfied with the services of your attorney?
Yes.
With regards to the charge of possession of drug paraphernalia from an incident of July 13, 2022, how do you plead?
No contest.
With regards to the charge of trespass on property after warning from an incident of July 13, 2022, how do you plead?
No contest.
I accept the pleas of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with these proceedings. You are entering the pleas of your own free will, and there are sufficient facts to accept the pleas. At this point, with regards to count one, possession of drug paraphernalia, I am adjudicating you guilty of that offense, giving you credit for 2 days, time served, Orange County Jail. With regards to the charge of trespass on property, after warning, I'm going to adjudicate you guilty of that offense, give you credit for 2 days, time served, Orange County Jail. I'm going to require that you not return to the place where this incident took place, which is 6115 South Orange Blossom Trail. I'm going to impose upon you all applicable court costs and fees and require that they be paid within a 1-year period. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you.
And no action on the out of bond, correct?
And yes, thank you for reminding me. No action on the other matter.
Thank you. So that's the phone number and that's the floor, so don't miss it. At the Orange County Courthouse downtown. So that is Tuesday. Don't miss that court date. All right?
Please state your name. Your name, please.
Marcus Lee Conyers.
You're here on a charge of resisting officer without violence. I've reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Counsel?
Yes, Your Honor. The offer from the state is an adjudication of guilt, credit, time served, and court costs. Mr. Conyers would like to accept and enter a plea of no contest. Additionally, on his out on bond cases, I am going to ask that you take no action. One, for the driving while license suspended, we're working on getting him a driver's license. So we didn't want to resolve that case. As to 2022 CF 6084 AO, no information has been filed. He was arrested May 28th. And they did file on the 2022 CF 5085 BO, Your Honor. However, given their unrelated charges, I would ask that you take no action.
And so state the 2022 CF 6084 AO, there was a no info?
No, Your Honor. When defense says that, she means that a notice of non-filing has been filed.
A notice of non-filing, okay. And is this plea here today contingent upon any action I may take on the other matters he's out on bond?
Your Honor, it's one of the factors, given that he has the out on bond. However, I did not see any type of,
Let me then, normally I don't do this, but if it affects his, because he's trying to plea out, I will let you know that I am considering on case number 2022 CF 5085 BO, revoking and setting it at a no bond status.
and Your Honor, I would ask that you not I don't know, I don't even think he has an attorney on that one. That was weird as well, too. Do you see an attorney listed?
Looking right now.
On the delivery charge, it's unrelated, Your Honor. As well as it's, the delivery of cocaine is a nonviolent offense. I do not believe that the state is asking that you revoke the out on bond.
It's my decision.
I know, Your Honor, I'm just making,
I understand, but I just want
Yeah.
to, because he's trying to plea out,
Mhm.
again, it's maybe one of those situations where I don't want him to be misled by what's happening in the courtroom, to think that if he pleads out today, he may be leaving today. And so I don't want that to be a factor. That's why I'm letting you know that I am considering at this point revoking on that case number, the 5085BO, and putting it at a no bond status. I see that you have your hand up. Please understand that everything you say is being recorded and can be used against you. If you want to run something by the attorney, I can give you a moment, no problem.
the only question he was gonna ask, Your Honor, is why you were revoked. Additionally, I would add that although he has some history, Your Honor, one thing that I saw was that he has no failures to appear. So I just ask that you consider that factor as well.
Yeah, I have looked at his record, and I have looked at this file. And so again, that's why I am letting you know beforehand, before he pleads, in case these things were a factor in having him decide to take a plea here today. I think it's only fair that he understand that.
Yes, sir.
He's considering revoking that case.
Why? Didn't do anything.
He's just asking why.
I understand.
You don't see an attorney, right?
Will that affect,
He doesn't have any attorney appointed on that either.
if he, that's,
So
I don't see
normally,
where there's attorneys appointed on that, so I will appoint, I don't know if I can, but by all means, if you all want to help him with those matters, and I will appoint you to represent him in the case number 2022CF5085BO
I'm trying
and
to
the
see, I don't see-
2022CT2910AO.
And I just point to the fact that, Your Honor, based on the new law violation, he's merely a pedestrian walking in the crosswalk when he was stopped by an officer. I don't see anything that he did that was egregious, Your Honor, that would be my only argument. It's
I
not,
understand.
I want to catch my Uber.
I know, just stop. So it's up to you. I can't do anything. He has
I
to-
didn't do anything wrong. I
So
just
do you
wanna
want-
catch my Uber.
I know, but do you want to accept the offer still?
You're not gonna get out.
I don't know.
I don't even have a court date. I didn't do anything wrong.
All right, and so at this point, is he going to plea out on that charge or not?
Do you want to accept the offer on the new law?
Yes,
Yes, Your Honor.
You wish to go forward with the plea?
sir.
Okay.
I can't get out.
I don't know. He said he's thinking about revoking. I don't know. I can't answer that question.
Thank you.
Mm-hmm.
Let me just make sure that he understands that the recommendation on the plea is a conviction. And can anyone in the courtroom with any degree of certainty guarantee that it will not affect the outcome of any of the cases that he is out on?
As far as points, Your Honor, I don't know that a resisting would affect these other than his points. So it's still, I don't know, it's still up to the client if he would like to resolve the case.
You want to take a moment to speak with him?
I was just trying to see what was going on, but. I know, we're not talking about that, I'm just letting you know, I'm advising you of that. So, yeah, I know, but he's saying it can affect that, I'm just letting you. Syndicate, so that's what it's saying. So if you were to. No, not to, well, not today, he's considering revoking, it has nothing to do with that.
I didn't do anything. It's my
Yes.
son's birthday today.
I understand. Yes, Your Honor. Ron?
Yes, he wishes to go.
He still wishes to
Okay.
plead. Oh, let me see.
Can you please swear him in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Thank you.
Sir, can you please state your full legal name?
Marcus Lee Conyers.
Thank you, and you can put your hand down, thank you.
Sir.
And sir, that you go over this plea form with your attorney,
Yes, sir.
and let the record reflect the plea form was signed in open court. And sir, do you understand the rights that appear on the front of this plea form?
Yes, sir.
Do you understand you are giving up those rights by entering a plea here today?
Yes, sir.
Do you understand the maximum and minimum penalties for the charge you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes, sir.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here today?
Yes, sir.
Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
Yes, sir.
Do you understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
Are you presently under any probation or parole for any other criminal matter?
No, sir.
With regards to the charge of resisting officer without violence from an incident of July 13th, 2022, how do you plead?
No contest.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea. At this point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for 2 days' time served. I'm going to impose upon you applicable court costs and fees, require that they be paid within a 1-year period. You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. With regards to the other cases, 2022 CT 2910AO, I'm not going to take action on that bond. With regards to case number 2022 CF 5085BO, I am going to revoke that bond and set it at a no bond status.
And you're taking no action on the 22 CF 6084 AO case, Your Honor?
Right, that other one, I've been informed that there's a no info.
Information has not been filed, Your Honor.
Information has not been filed. So hold on. So let me just make sure I'm understanding this. Is the state going to pursue this, or is the state not decided yet?
State has not decided yet, Your Honor.
Okay. And forgive me, because I misunderstood, and I thought the state was indicating that they were not going to file on it. And so at this point, with regards to case number 2022 CF 6084, I'm going to revoke on that and set that at a no bond status.
Your Honor, he's been arrested since May, and the state has yet to make a filing decision, and we're in July. I would ask that you take no action on that case. It's been well over 30 days.
State?
That is correct, Your Honor. He was arrested May 27th, and the state has not made a formal filing decision with regard to 22 CF 6084.
Do you know when the state is going to make a charging decision?
I do not, Your Honor. My argument with regard to drug cases is that unfortunately it does take FDLE more than 30 days in order to analyze the substance.
And
So,
it
but I
just-
don't know how long it does take, but I know it's longer than 30 days.
You're saying the delay in that particular case is because of the FDLE lab?
The delay in 90% of our drug cases is because of the FDLE lab, Your Honor.
All right. Based on that information, and thank you for the clarification, I will take no action. Strike what I said before, I'll take no action on that one, which is the 2022 CF 6084AO. All right, thank you, sir.
Took that bond out? Do I have a bond?
No.
Great, I didn't do anything.
Could you just say, any case that he doesn't have an attorney appointed, that we could be appointed? Because I don't see anything on that
What
one.
don't, I would rather play it safe. I don't see any attorney appointed.
Correct.
But I would play it safe and say I'm appointing the Office of the Public Defender to
Thank
represent
you.
them on all of them.
Thank you, Your Honor.
Okay. Okay. All right, thank you. Please state your name.
Justin Demetrius Rodriguez.
And sir, you're here with regards to a charge of petty theft. I've reviewed the charging document and I find probable cause. Bond is set at $250.
Your Honor, I believe he qualifies for pretrial release. I would ask for pretrial release. I don't see any history.
No objection.
He qualifies for PTR? PTR?
Yes, Your Honor, it should say yes on your sheet.
Bear with me a moment.
Conditions are, once you get released.
All right, I will release him on pretrial release. Thank you.
Any conditions, Your Honor?
I'm going to require that he not return to the location where this occurred, which is, I believe, Orlando International Airport.
Yes, Your Honor.
I'm also going to require that you comply with the requirements of the pretrial release program.
Yes, sir.
I'm going to require that you possess or consume no alcohol or non-prescription drugs. Okay?
Okay, question, sir.
Ask the attorney at the question.
Thank you, Your Honor.
All right, thank you.
Thank you, sir.
Your Honor, Washington bonded.
Thank you.
Craig also bonded.
Washington and Craig, thank you. Please state your name.
Giovanni Copeland.
And you are here with regards to a matter of a warrant, a capias for failure to appear for arraignment on a charge of no motor vehicle registration. I'm appointing the Office of the Public Defender to represent you.
Your Honor, the offer from the state is a withhold and court cost. Mr. Copeland would like to accept and to plea no contest.
I'm not going to take a plea at this time. I don't have enough information. I do not have a driving record.
It's a no motor vehicle registration, Your Honor.
Understood.
He has no,
I don't have a driving record. Does anyone have a driving record?
No.
it, can you pull Rebecca? Thank you. Usually with the, I didn't know. No registration. Bun.
I mean, I can afford it, but I don't have nobody come up here to pay it for me.
Just in case, thank you. I don't have enough information on this matter to take the plea.
Yeah, but I'm trying to see before I print it, what type of information?
I don't know.
you need.
For,
What type of
they want the,
information do you need besides the driving record, Your Honor?
Do you have a copy of the citation, and do you have a copy of the, or of the charging document and a copy of the driving record?
You said a driving record?
not you, not you.
Yeah, and please, remember, if you say something, it's all being recorded and can be used against you. All right, but you have, counsel here, the attorney from the Public Defender's Office, and if you have questions, you can ask her, okay?
Madam Clerk, could you print the citation? Thank you.
Right, and do you have a driving record? Thank you.
Thank you. I don't understand that.
I've reviewed the citation, and I have reviewed the driving record. Thank you for providing, it's a summary of his driving record for the state of Florida. Thank you for providing that. I'm not going to take a plea. And sir, the bond amount, as I said prior, was set at $2,000. Thank you. Santana bonded, thank you.
I'm done.
You'll bear with me a second, please? Please bear with me.
Bonded.
Thank you. Ms. Tyson? All right. You are here on a capias for failure to appear on a charge of driving while license suspended or revoked with knowledge. Bond on that has been set at $2,000.
The state has made an offer of an adjudication of guilt, credit time served, and court costs. Ms. Tyson would like to accept and enter a plea of no contest.
Again, I'm in that situation where I don't have enough information to know.
We have the driving record was provided by pretrial.
Okay. Again, and I don't know if it's leading towards habitualization. I don't know what a driver, that's why I ask. I don't like to just routinely plead these out without having all of the information, out of pure precaution. Because I want to make sure that when someone pleads out, that they know the consequences and I know the consequences, if any.
Your Honor, I did go over the consequences with my client. We did discuss that. And she would like to still accept the offer as she cannot afford the bond and she will be held here at no bond and she has children she needs to attend to.
Well, there's a difference between taking a plea because you feel you're forced and have no other choice and the possibility of having a request for a bond modification.
Not that I had no other choice, like,
And I don't mean to be rude, it's just that everything you say is being recorded, can be used against you. If you want to talk to the attorney, please, by all means.
If you want.
So,
Your Honor, again, she understands the consequences. I do not see that this would HTO her based on what I'm looking at. We went over all of those things. She understands that driving while license suspended is a habitual offense, and she could get her license suspended if she has the 3 within that period of time. I went over all of that. She would like to accept the state's offer, knowing all of that, and enter a plea of no contest.
if I were,
Can't afford any bond, given that she has
In-
all
yeah.
that.
I don't want to put a person in a situation where they plea on a case, give up all the rights they have, because they feel that they have no other choice. If you want to get into possible terms of release, that's something else. But if you want to show me, if anyone wants to show me a driving record, I might consider that plea.
Rebecca, can you print?
Your Honor,
one?
may I approach? It's the same one.
Oh, thank you.
Okay, thank you.
No, it's not.
Just to let you know, one thing I look for at the citations is whether or not there was an accident involved.
Oh, you already gave him?
I've got, I've been handed a DHSMV search.
Your Honor, you should have had one attached to your face sheet.
No,
For Cindy Tyson?
let me see. I've got no. Face sheet, what is it? Oh, that's the face sheet? Shouldn't be. This is Santana, right. There we go. So, let me give this back to the state. Based upon my review of her driving record, I will not take a plea on this.
You have to set it for plea. I'll set it for plea. There's nothing I can do at this point.
So
I
now,
didn't see anything on your driver record. I don't know.
counsel, did you want to see if the court might modify something?
She cannot afford a monetary bond, Your Honor. But unless it's an ROR, she's gonna sit here until we can get her before the judge downtown to set a plea when she has children to get to, Your Honor.
There's a history here,
I
and
see,
so,
driving, I didn't see any, unless I'm missing something, I didn't see any type of, driving while license suspended that would,
I'm not talking about just habitualization. There is a history here. And the way I read the history is that she's not taking her driving privileges seriously.
and I don't,
So if you don't think you wish to see if there's anything that can be modified, then let's try to get her as quickly as possible before a judge downtown. And so if there's no modification,
Your Honor, the only thing I would ask for is an ROR. She can't afford a monetary bond. I don't even see much of a history. And now she's gonna sit here with, she just had a baby, and be held here until we can get her downtown to plead this out, which is gonna be the same thing, Your Honor. The state's gonna offer the adjudication credit time served. I don't know what other option she has other than that.
and so what are you requesting, and
No, they're not.
what are you requesting, counsel?
ROR.
Okay, state, do you have any position?
Your Honor, may I offer an alternative that you
Please.
may accept?
All right,
It is an adjudication on this driving while license suspended, and you seem to have concerns that she is not taking her driving privileges. If I were to make it part of it that she either take the driving while license suspended, the driving class or the 8-hour class that has to be completed within 30 days of release, would that be acceptable to the court?
if you're trying to fashion a sentence that will help her avoid being in these types of situations in the future, I will listen.
Yes, Your Honor. Would that be acceptable to the
Well, so
court?
what would be the offer?
It would still be a credit time served offer, Your Honor, to get her out today, but within 30 days of her release, she would have to take that class.
Which class? I believe that there is a dualist class.
It's a driving class, Your Honor.
No, driving class is a 4-hour class that is not really teaching anything with regards to driving while license suspended. I
There is
believe-
also an 8-hour class then, Your Honor.
Again, that doesn't address the dualists.
That doesn't address, I'm sorry.
Her underlying charge is a driving while license suspended. It's a dualist. And so the 4-hour or the 8-hour driving class does not address the dualist, the charge that is before the court. I believe that there is a class, there used to be a class with regards to driving while license suspended.
If you give me a moment, Your Honor, I'll see.
Sure.
These are choices.
How many hours it is, but that is how it is listed, is as a dualist class.
Right. Now, that would make sense for an individual to take if you all are trying to help the individual in not repeating certain type of behavior and trying to get their license reinstated so that they don't wind up in the same situation and yet wind up being closer to habitualization. There's an indication that she has family that she needs to get back to. And so why not just do something that'll not just help her today, but will help her in the future to the extent where she won't have to worry about being away from her children because she will have, hopefully, a valid driver's license.
So is that acceptable, Your Honor? The Dwellis class within 30 days of release?
Well, sometimes you can't complete the class within 30 days. So usually what you would say is that you are to show proof that you have signed up for the class within 30 days' time, and that you've taken the class within 90 days' time.
I'm fine with that.
Yes.
No,
I just want to make sure I'm able to find it.
yeah.
And is that offered through the Safety Council?
Yes, there does appear to be a course that you can do through the Safety Council.
All right, and can you please swear her in?
Not sure.
Thank you.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you.
Let me make this clear before I go through with the plea. Because she's not being put on probation, which is the only way to ensure that she is going to take the class or otherwise suffer consequences with this case, when you phrase it in that way, show proof of enrolling within 30, that would be proof to the clerk's office, proof of completing within 90. The wording is that if the proof is not submitted to the clerk's office within the required time, the clerk's office will issue a further suspension on your driving privileges. So you will have two matters to clear up. Do you understand what I'm saying?
Yes, sir.
And hopefully that'll help you get your license on track. But if it doesn't, it's going to make it harder for you to get your license on
Correct.
track. You understand that?
Yes, sir.
You still want to go forward with the plea?
Yes, sir.
Okay. And so let the record reflect the plea form was signed in open court. And can you please state your full name?
Wendy Tyson.
And did you review the plea form with your attorney?
Yes, sir.
You understand the rights that appear on the front of the plea form?
Yes, sir.
Do you understand you are giving up those rights by entering a plea here today?
Yes, sir.
Do you understand you understand that by entering a plea here today, you are going to be receiving a full-fledged criminal conviction, so that if you are ever asked if you've been convicted of a crime, you will have to answer yes.
Yes, sir.
And do you understand the maximum and minimum penalties for the charge that you are pleading here today on?
Yes, sir.
Are you entering the plea of your own free will?
Yes.
Are you under the influence of any alcohol, drugs, or medication that might affect your thinking here
No.
today? Do you suffer from any type of mental condition or disease that might affect your ability to think clearly?
No, sir.
Do you understand that entering a plea of guilty or no contest to this charge can lead to deportation from the United States if you are not a legal citizen of the United States?
Yes, sir.
Are you presently under any type of probation or parole for any other criminal
No,
matter?
sir.
Are you satisfied with the services of your attorney?
Yes, sir.
With regards to the charge of driving while license suspended or revoked, in case number 2021-CC4556AO, how do you plea?
No contest.
I accept the plea of no contest. I find you are alert and intelligent. You understand the rights and the penalties associated with the charge. You are entering the plea of your own free will, and there are sufficient facts to accept the plea.
Yes, sir.
At this point, I'm going to adjudicate you guilty of the offense. I'm going to give you credit for 2 days' time served, Orange County Jail. I'm going to require that you enroll and complete the driving while license suspended class. And I'm going to give you 30 days to show proof to the clerk's office that you have enrolled in the class, and I'm going to give you 90 days to show proof that you have completed the class. So there's going to be a certificate that is provided to you, and you take a copy of that certificate and you give it to the clerk's office. If you do not, as we spoke before, I'm going to order the clerk's office to do another suspension, to suspend your driving privileges. Okay?
Yes, sir.
I'm going to impose upon you court costs and fees. I'm going to require that they all be paid within a one-year period.
Yes, sir.
You have 30 days to appeal the decision of the court in writing. If you cannot afford an attorney for appellate purposes, one can be appointed for you if you qualify. Thank you.
Okay, Judge, so that was in.
$90. With proof to the clerk's office. Right.
Hmm?
4 days for.
Thank you. Please state your name.
Cornell Atwell.
And sir, you are here with regards to a charge of robbery with a deadly weapon and mask. I am appointing the Office of the Public Defender to represent you at this time. I have read the charging document and find probable cause. Is there any comment from the state or defense before I address bond or conditions?
Your Honor, this is a first-degree felony. It's punishable by life. At this time, state would ask defendant be held no bond.
Defense?
Your Honor, if you would like to use your discretion to set a bond, I would ask that you use your discretion.
All right, thank you. And I've looked at this file before. Let me take another quick look at it. Give me a moment. I just want clarification on some information I have here. In order to talk to her, I have to go off record here because I see another mic over there. Put this at a no bond status. All right, thank you, sir.
Your Honor, I would ask that he not return to the location. This happened at a quick stop.
A question I have, and this is more a practical question. So when it's set at a no bond, he's not going to be leaving right now. If I do a no return, but isn't that addressed at a time where I'm sure that the public defender's office or his defense attorney is going to be filing a motion to set bond in the future? Wouldn't that be
You are
addressed
correct,
at
Your
that
Honor,
time?
yes. It will be addressed at a later date. It's just, you're correct, yes.
I know, I just wanted to make sure I'm not assuming anything, but,
No?
okay, all right, well, thank you. All right, thank you, sir.
Your Honor, Benjanet Sarah, she's mental health.
Okay, Sarah Begant, I'm appointing the Office of the Public Defender to represent her. I've read the charging affidavit, find probable cause for the charges. Count 1, burglary of conveyance, bond is set at $3,500. Count 2, resisting officer without, bond is set at $100. Count 3, possession of drug paraphernalia, bond is set at $100. Are you waiving her appearance, defense?
I am waiving, Your Honor, but
You need a moment?
I would ask that she also be screened for mental health pretrial release.
Okay.
So.
Yeah, I was
because
wondering
there may
about
be
that.
some mental health issues.
It's the bond amounts as stated, or mental health pretrial release if she qualifies.
Thank you, Your Honor.
And again,
And
Your
I will
Honor,
waive, sorry, I'm sorry.
again, Your Honor, I would ask for no return. This took place at Thornton Park Central Garage.
All right, and if she meets the bond amount or the mental health pretrial release, then I will require that she not return to the place where this incident took place, which is the parking garage in Thornton Park.
Yes, Your Honor.
Please state your name. And you are here on a couple of matters. Bear with me a moment, please. You're here on a capious on a failure to appear with regards to a charge of criminal mischief with damage of $1,000 or more. Bond on that has been set at $1,000 plus pretrial release with conditions of no contact directly with the victim, co-defendant, or witness. Do not possess, consume any alcohol, illegal drugs, or controlled substances without a valid prescription, and do not possess any weapons or firearms. With regards to the second matter, it is a charge of resisting officer without violence. I've reviewed that charging affidavit, find probable cause, bond is set at $500.
Your Honor, on the resisting, I would ask for straight pretrial release.
Is he qualifying for PT? Yes, I'm sorry, you're right. State, any?
No objection.
All right, thank you for pointing that out. And yes, no objection to his being released via pretrial release. On those matters, he still has the bond and PTR on the other, on the warrant. Anything else, State Defense?
No, Your Honor.
All right, thank you.
Ryan Bolden, he bonded.
All right, thank you. Please state your name.
David Labo.
All right, sir, you're here on a couple of matters. First is a charge of cocaine possession. Second count on that matter is a charge of destroying evidence or altering in order to conceal. I've read the charging affidavit, find probable cause. Bond on count one is $1,000, bond on count two is $150. You also have a matter of a charge of possession of drug paraphernalia. I've reviewed that charging affidavit, find probable cause. Bear with me a second. I believe that bond on that one, while the document says $500, I believe it should be $100.
No objection, Your Honor.
All right, thank you. Anything else, State Defense?
Nothing from defense, Your Honor.
All
No,
right,
Your Honor.
thank you. Should have more of these. With a few convictions today. Did some others before. Sir, you're here on a charge of grand theft, third-degree motor vehicle. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond on that matter is set at $2,000. I'm also aware that you are out on bond on case number 2021 CT 1286, and I'm going to revoke that bond and put it at a no bond status.
So I'm not on bond, Your Honor.
Okay, and thank you for letting us know. Let us look into this for a moment, okay? And see if we can find information on that.
Rachel. Listen. Is this you? This is the old firm. That's what they have. Fingerprints cleared, right?
Hmm?
They did his fingerprints and everything, right? Yep.
He was arrested on it on December
it.
5th, 2021. The driving case.
Yep. You have an operating a motor vehicle. Seen here at IA's first appearance. Q. You have Rachel Shaw. That's the out on bond. You are out on bond. That's what he's referring to.
All right, so
It's
I looked into the 2021 CT 12886AE, and the information there reflects the information in this present case with regard to his name, birth date, et cetera. Is there any, does anyone have any information that might indicate otherwise?
Your next court date is on the 19th, so they could probably resolve it then. But contact Shaw Rachel. Yeah. I don't have her information. Your Honor, he does have an operating a motor vehicle. He has Rachel Shaw, private counsel.
He's got private counsel on that case?
Yes, Rachel Shaw. He has a court date on the 19th
All right,
before Martha Adams.
okay, thank you. And so, as I said, the bond on the case before us today is $2,000, and I'm invoking and in case number 2021 CT 12868E and setting it no bond. All right, thank you, sir. Your name, please?
My name is Franny Laura.
Franny Laura, thank you. You are here with regards to two charges. I've reviewed the charging affidavit and I find probable cause. First is a count of battery on a law enforcement officer. Bond on that is set at $2,500. Second is a count of resisting officer without violence. Bond on that is $1,000. I'm appointing the Office of the Public Defender to represent you.
Your Honor,
Yes.
he does qualify for pretrial release. I would ask for pretrial release in this case, given he has no criminal history and he qualifies, Your Honor.
State?
No objection.
Okay. Give me a moment here.
And
You have a question? You have a question?
so much. I just wanted to apologize.
All right, I will agree to release by pretrial release. I'm going to require that he not return to the place where this incident took place, which is the Sea Isle Apartments, and that he have no contact with any alleged victims or witnesses in the case. All right, thank you. All right, thank you. I appreciate that. All right, thank you. Let me start in the cases of Robert Edward Minis Mendez. I am appointing the Office of the Public Defender to represent him. With regards to case number 22CF8169AO, I have read the charging affidavit. I find probable cause. With regards to count 1, robbery with a firearm, that is set at a no bond status. With regards to count 2, possession of weapon or ammo by a convicted felon, that is set at $4,000. Addressing case number 22CF8170AO, I've reviewed the charging document, find probable cause. Bond on count 1, possession of weapon or ammo by a convicted felon. Bond is set at $4,000. Count 2, possession of weapon or ammo by a convicted felon. Bond is set at $4,000. Count 3, resisting officer without is set at $500.
Your Honor, with regard to 22CF 8169, I would ask that you also do a no return as this sorry, never mind. It's just force of habit.
No problem. And it's okay.
Was his appearance waived?
I will waive the appearance, Your Honor.
All right, thank you. Please state your name.
Matthew Robert Moore.
You are here with regards to charges of use of an anti-shoplifting invention and grand theft third degree. I've reviewed the charging document, find probable cause. Bond on count 1 is set at $1,000. Bond on count 2 is set at $150. I'm appointing the Office of the Public Defender to represent you at this time. Anything else, State Defense?
No.
Your Honor, I would ask that he not return to any target.
All right, I'm going to require as a condition of your release that if the bond amounts are met, that you not return to any Target store. Thank you. Okay, thank you. With regards to the cases of Luciano Otto Brino, I'm appointing the Office of the Public Defender to
And
represent him.
yes, I will waive the reading, and Your Honor, I will waive his appearance today.
Thank you. Any comment from the state?
No comment, Your Honor.
All right, thank you. And just for the record, we're addressing cases number 2022CF3251 and 2022MM4724AO. The bonds, that was $2,500 on count 1 in 2022CF3251. And count 2 of that same case is bond of $1,000. Then going on to 2022MM4724, resisting without, bond is set at $500, and possession of drug paraphernalia is set at $100. Thank you. This is a case number 2022CF8163. I'm appointing the Office of the Public Defender to represent him.
And Your Honor, I will waive the appearance. I would have just asked that you use your discretion in this case to set a bond. I believe the weapon was a stick, Your Honor.
That's correct.
A wooden stick. And being that the facts aren't egregious, Your Honor, I would just ask that you consider using your discretion to set a bond.
Any comment from the state?
Your Honor, in my paperwork, it came in with a $10,000 bond. I have no objection to that.
Okay. Thank you. And so I've reviewed the charging document, find probable cause, bond is set at $10,000, not to return to the Amoco gas station at 601 North John Young Parkway.
Thank you, Your Honor.
Please state your name.
Rodriguez Powell.
You are here on 3 charges. Count 1 is fleeing or attempting to elude a law enforcement officer with sirens and lights activated. Count 2 is grand theft, 3rd-degree motor vehicle. Count 3 is no motorcycle license. I have reviewed the charging document, find probable cause. I am appointing the Office of the Public Defender to represent you. Is there any comment from the state or defense?
No, Your Honor, count 1, he is entitled to bond on count 1, Your Honor.
Any comment from defense?
Your Honor, just ask that you set a reasonable bond on count 1.
Okay. And let me just double check. I am going to set bond on count 1 at $5,000. Count 2, I'm setting that at $2,500. Count 3 at $500.
Thank you, Your Honor.
Thank you, sir.
Thank you, sir.
Please state your name.
Jamie Ruiz.
Sir, you're here with regards to a charge of grand theft, 3rd degree. I've reviewed the charging document, find probable cause. I'm appointing the Office of the Public Defender to represent you. Bond is set at $500. Anything, state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you. Please state your name.
Raven Leon Schaefer, 12/30/1993.
Thank you. Sir, you're here on 4 charges. I've reviewed the charging affidavit and I find probable cause. Count 1 is possession of meth with intent to sell or distribute. Count 2 is possession of methamphetamine. Count 3 is possession of cocaine. Count 4 is possession of drug paraphernalia. I'm appointing the Office of the Public Defender to represent you. Is there any comment so far from the state or defense?
No, Your Honor.
No, Your Honor.
All right, on count 1, bond is set at $15,000. Count 2, $1,000. Count 3, $1,000. Count 4, $500. You are also out on bond with regards to case 2022 CF 4179AO. I'm going to revoke that and set that at a no bond status. Thank you, sir. Please state your name.
Deontay Slaughter.
You're here on a couple of matters. First is a charge of trafficking in meth, MDMA. Second is a count of grand theft, 3rd degree, motor vehicle. I've reviewed the charging affidavit, find probable cause. I am appointing the Office of the Public Defender to represent you. With regards to count 1, bond is set at $50,000. With regards to count 2, bond is set at $150. The other matter that brings you here today is a charge of driving while license suspended or revoked, noted as a subsequent offense. I've reviewed that charging affidavit, find probable cause, bond on that is set at $500. Is there anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir. Please state your name.
Jerome Thomas.
You are here with regards to a charge of grand theft, 3rd degree motor vehicle. I have reviewed the charging affidavit and I find probable cause. I am appointing the Office of the Public Defender to represent you. Bond is set at $5,000. Is there anything from the state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you. Thank you, sir. Please state your name. Oops, thank you. It's on. Oh. Got it. You're here on several matters, sir. I'm appointing the Office of the Public Defender to represent you at this time. Let's start with case number 2022-CF7031. That is a charge of grand theft third degree. That is via a warrant. The judge put bond on that in the amount of $5,000. Next is a matter in case number 2022-CF6935. That is a warrant arrest for a charge of fleeing and eluding. Bond is set at $5,000. Count 2 is reckless driving. Bond is set at $500. Count 3 is no proof of insurance. Bond is set at, or I should say, no insurance. Bond is set at $250. You also have a warrant arrest with regards to a charge of grand theft in case number 2022-CF6927. The judge set that bond at $2,500.
And
Any comment from the state or defense?
No, Your Honor.
on the, Your Honor, on the out-on bond, I would ask that you take no action. He was arrested May 25th, and to date, no formal charges have been filed. I believe he was on pretrial release, and I'm pretty sure they handed you a revocation of pretrial release, right? So I would just ask that you just set a bond in that case, given that he has no other criminal history and the state has not made a filing decision to date.
Any comments from the state?
The state has not filed any formal charges as of this date. He was arrested May 24th.
Okay. With regards to that other case, 2022-CF5954AO, I am revoking that bond and setting it at a no bond status. Which box do I do this?
This is RCC's.
Got that? Okay. Please state your name.
Taylor Trapp.
You're here with regards to an arrest. I've reviewed the file. There is a warrant arrest for count 1, dealing in stolen property. The judge set that at a $3,500 bond. Count 2 is giving false information to a pawnbroker. Judge set that at $3,500 bond. Count 3 is grand theft motor vehicle. The judge set that at a $5,000 bond. Count 4 is petty theft. That is set at a $500 bond. I am appointing the Office of the Public Defender to represent you. Anything else, state or defense?
No, Your Honor.
No, Your Honor.
Thank you, sir. Please state your name.
Mariana Turner.
Good afternoon. And you are here on a warrant arrest with regards to a charge of armed burglary of a conveyance with a firearm. That has been set at a no bond status. I'm appointing the Office of the Public Defender to represent you. Is there any comment from the state or the defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir. And just for the record, there are conditions of release, but it's a no bond, so that'll be addressed at a bond hearing.
Yes, Your Honor.
Yeah. Please state your name.
Harry Worth.
Sir, you are here on charges of grand theft, third-degree motor vehicle, and resisting officer without violence. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Count 1, grand theft, bond is set at $1,000. Count 2, resisting without, bond is set at $100. Anything else from the State of Defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir. Please state your name.
My name is Ronald. My name is Ronald Wilson.
Thank you. You are here with regards to a matter of possession of MDMA ecstasy. I've reviewed the charging document, and I find probable cause. Bond on that is set at $1,000. By the way, I'm appointing the Office of the Public Defender to represent you in all of the matters before us today. You are also here on a warrant arrest.
Your Honor, I will waive the reading.
All right, thank you. And on that case, for the record, it is 202221, I'm so sorry, 2022 CF 7269. That has been set at a no bond status.
And Your Honor,
It's an F3, Your Honor. Yes,
right.
he
He's
is
entitled.
entitled to bond, because it's an F3.
And is there any recommendation from either side?
No, Your Honor.
No. Let me see.
I'm sorry.
Your Honor,
Go ahead.
I would just ask for a $5,000 bond.
And I'm looking at a history sheet, and I just want to verify again, since I'm learning how to read this particular sheet, I'm asking the state, for my reading, it doesn't seem to be a serious history.
Oh, no, Your Honor, he does not appear to have serious history.
Okay,
He does appear to, yes, Your Honor, yes.
all right, and if you'll just bear with me a second, please. Yay. That's why I couldn't find it before.
All right.
All right, thank you. At this point, I am setting bond at $7,500. I am going to require that you have no contact, directly or indirectly, with the alleged victim or any witnesses to the case. I'm going to require that you possess or consume no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Anything else, State Defense?
Your Honor, I would ask that he have no unsupervised contact with any minors.
That's reasonable. I'm going to require, sir, that you have no contact with, well, no supervisory contact. What? I'm sorry, how did you word it, State?
That he have supervised contact with any minors.
Thank you. It's been a long day. Please forgive me, sir. So I'm going to require that you have supervised contact with any person under the age of 18 years of age. In other words, you cannot be alone with any individual underneath the age of 18. If you, and please forgive me, I don't mean to be rude, but everything you say is being recorded, can be used against you. It appears you have a question. Do you want to talk to the attorney first about that?
Oh, Your Honor, I'm sorry, I was looking into, was, one of the conditions, you said no contact with minors? Is that-
With the victim or witnesses, and and supervise contact with any person under the age of 18. That's what the state requested, right? Supervise
Yes.
contact.
I would just ask, he has, children.
Okay.
Do you have any objection with him having contact nor regularly with his children?
If it's supervised, yes. I have no objection.
Right, and so it's supervise contact. In other words, he cannot be alone with a person under the age of 18. And sir, if there are any things that come up, you can always contact your attorney at the Public Defender's Office and see if they can help you tweak the order or modify it in a way that it may be necessary in the future.
I'm not sure, but we already issued a violation of probation today. Just so you know, I don't know when you were off. I see there was a. Huh? I really don't know. Yeah, that's the warrant. I'm not sure what's going, can you see that? There's it's showing, he's saying he wasn't on probation, but I see that there's a probation violation packet that was filed. I really couldn't tell you.
It appears as though he should be on probation until July 19th. It's for 21 CT. It's listed on the face sheet.
Okay, so that's what they're saying. He's saying he was off. They haven't given it to you yet, but that's what's there.
21 CT 2867. He was placed on probation July 19th of 21, so he had another 5 days.
Okay. So it hasn't been hit yet, but you're gonna, I don't know. I don't have that information, at this time. I don't know. 'Cause I know you're saying your probation officer said you were off of probation, but you're not even here today for that, but I'm just telling you, it's showing me that there's a warrant for violation of probation coming. I wouldn't find out yet. If you can see, I can't see it. I don't know.
Just in case, I know the two of you are talking, I don't mind you taking a few more moments. I'm going to go off record. Just
Oh,
in
yes,
case
Your Honor.
it's being picked up by the mics, okay?
Yes, Your Honor.
To appear for sentencing on charges of robbery and battery. The capias has been set at a no bond status. You are also here on a charge of resisting officer without violence. I've reviewed that charging affidavit, find probable cause. Bond on that is set at $500. I'm appointing.
Excuse me?
Bond on that is set at $500, and I am appointing the Office of the Public Defender to represent you. Did you understand everything I said?
How much my bond on that?
The bond on the warrant
Resisting.
is, and just to remind you that everything you say is being recorded, can be used against you. But if you have a question about this, if you want to talk to the attorney for a moment about it,
She just asked what was the bond amount for the resisting, and I explained it was 500, correct, Your Honor?
okay. Did you hear everything that went on? Do you need a hearing device?
No, yes, sir, I do.
You do need one?
Yes.
Let's make sure that you understood everything that happened, okay? So let's get her a hearing assistance device. Testing, testing. Can you hear me? Can you hear me with that?
No, I don't hear nothing.
And that was the testing, testing. Hello, testing, testing. We had the same situation with the gentleman before. This morning, apparently the device may not be working. Is there a way to find out if it's working or not? Testing, hello, testing, can you hear me any better? And she's saying no. And so who would be able to, who's in charge of that equipment? Who would be able to see if it's working or not? Okay, well, I'd appreciate it if you can help with that as,
Okay, you said my bond was set at 500 for.
yeah. This is what I'm going to do because it's important that you understand everything that is being said here today. I'm going to ask defense counsel if you would take a moment and just make sure that she understands everything that went here today, and if she has any questions about it.
So. Thank you, Your Honor.
All right, thank you. I have no further files in front of me. Anyone have anything else?
Nothing from the state.
Nothing from defense.
All right, thank you all. Court will be in recess till tomorrow, going off record.
Good morning, Your Honor. This is Rafael Barreras, State Certified Court Interpreter. I have been previously sworn.
Good morning.
Good morning, Your Honor.
Do you need to test the equipment, make sure it's working?
Yes, sir. If you allow me just a moment, please.
Early.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, thank you. Sir, can you please state your full name?
Guzmán Brito. Cristian Guzmán Brito.
Cristian Guzmán Brito.
Sir,
Yes.
you are here with a charge of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I'm setting bond at $2,500 to have no contact whatsoever with the alleged victim in the case, no contact directly or indirectly. That means that you cannot speak to the person in person. You cannot telephone them, you cannot email them, you cannot text them, you cannot try to communicate with them by any type of internet or social media platform. Also, you cannot have another person try to communicate on your behalf. This also means that you cannot accept any communication from the alleged victim. I'm going to require that you maintain a separate residence, that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. In this particular case, I'm also going to direct the sheriff's office to go and search and look for a firearm that is supposedly located within the premises.
Okay.
Okay,
The arrest affidavit had an indication that there was a firearm in the premises and that the alleged victim feared that a weapon would be used against her and therefore had hid it. I just want to make sure that if this weapon exists, that this weapon is taken out of this equation until this matter is resolved. I'm also going to require that you maintain a distance of at least 500 feet away from the alleged victim at all times. That means 500 feet away from her place of residence, her place of employment, her place of worship, her place of education, and any store that you know that she frequents. You may return, if applicable, one time to the residence with the assistance of law enforcement to pick up any personal belongings you have there.
Okay.
I'm going.
okay,
There is a possibility that DCF, the Department of Children and Family, may become involved in this situation. It's just a possibility. So if they do become involved and if they require some type of compliance by the parents with regards to the minors in this situation, then I'm going to require that you comply with any DCF requirements as well. I also have an indication that you are out on pretrial release on a separate battery domestic violence related. Thank you.
Okay.
Okay, I've just been handed notice of revocation of pretrial release signed by Darnell Hilbert, Community Corrections Officer. Did you get a copy, defense?
No, Your Honor, we usually don't get a copy, but I understand.
All right, so I am signing the order that is revoking the pretrial release on that matter, and I am setting that matter at a no bond status.
And, Your Honor, just so my client's clear, I know out on bond, the judge allowed contact for the purposes via text for the purposes of the children. Are you eliminating that altogether, or?
Thank you for asking, and yes.
Okay.
I
Just
think
so
we
he
need to
knows.
stabilize the situation, but I appreciate you asking that. Is there anything else that perhaps will help them understand what they can or can't do? Anything else you see in the file?
Nope, it was just that. I just wanted him to be clear that
Okay.
that has been eliminated.
All right, thank you very much. And sir, do you understand everything that has been said?
Sí, señor.
yes, sir.
All right, thank you very much.
Your Honor, the interpreter can respectfully request the case number for this last defendant, please.
2022 MM 4729.
Thank you, Madam Clerk.
I'm so sorry. What happened with Rios Perez? Okay, thank you.
Your Honor, the interpreter can inquire, do we have another party in the gallery that requires the interpreter as well?
Yes, that's correct. There's someone in the booth, okay?
Thank you, Your Honor.
And this is the, please state your name.
Por favor, dígame su nombre.
DNA.
Yanni.
Okay, she needs the headset.
Do it on the
Oh, you-
loudspeaker, because both parties need the Spanish interpreter.
Got it. Okay, well, try this. Let me do this before we swear him in. And This is with regards to a matter of battery domestic violence related.
Esto es un cargo de agresión relacionado a la violencia doméstica.
I've reviewed the charging document and I find probable cause.
He revisado la acta acusatoria y determino que existen indicios razonables.
I am appointing the Office of the Public Defender to represent you.
Voy a designar las oficinas del defensor público para que las represente.
And we have an individual in the booth. If you could swear him in now, thank you.
Tenemos un individuo como testigo, le vamos a dar juramento en este momento.
Raise your right hand, please. Do you
Por favor, levante su mano derecha.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Usted jura solemnemente o afirma que el testimonio que usted dará en este caso será la verdad, toda la verdad y solamente la verdad ante Dios.
Sí.
Yes.
Please state your name for the record.
Por favor, dígame su nombre. Señor, espere, por favor. Caballero, por favor, dígame su nombre para que conste en actas despacito y en voz alta, por favor.
Seferino Lara.
Seferino Lara.
Sir, this is an attorney representing the Office of the State Attorney.
Caballero, este es un abogado representando a la Fiscalía.
I'm going to give her an opportunity to ask you questions.
Le voy a dar una oportunidad a ella que le haga usted unas preguntas.
Counsel, you may inquire.
Licenciada, ¿puede proceder?
Good morning, sir.
Buenos días, caballero.
Buenos días.
Good morning.
How do you know the defendant?
¿Cómo conoce usted a la acusada?
Es una persona bien. Nunca, en todo el tiempo que estuvimos juntos, nunca fue agresiva. Hasta ese día.
Person in all the time that I've known her, she's never been aggressive.
Let me ask it another way.
Le voy a preguntar de otra manera.
What is your relationship with the defendant?
¿Cuál es la relación suya con la acusada?
Novia.
Girlfriend.
Do you live together?
¿Ustedes conviven?
Nos separamos apenas.
We just separated.
While this case is pending, would you like to have contact with her?
Mientras que este caso esté pendiente, ¿usted desea tener trato con ella?
Sí, no tengo problema.
Yes, I have no problem.
Has something like this happened before?
¿Algo semejante ha sucedido anteriormente?
No, nunca.
No, never.
Were drugs or alcohol involved in this incident?
¿Drogas o alcohol estuvieron involucrados en este accidente, en este incidente?
No.
No.
Thank you. I have no further questions.
Muchas gracias, no tengo más preguntas.
Defense, do you have any questions?
Defensa, ¿tiene usted alguna pregunta?
No questions, Your Honor.
No tenemos preguntas.
All right. Any comments before I address the issues of release, state, defense?
Fiscalía, defensa, ¿tienen algo que opinar antes que yo me tramite las condiciones de liberación?
Nothing from the state.
Nada por parte del fiscal,
Nothing from defense, Your Honor.
nada por parte de la defensa, su señoría.
All right, thank you. At this point, I am setting bond at $1,500.
Muchas gracias. En este momento voy a programar la fianza en $1,500.
I'm going to require that there be no hostile contact between the parties.
Voy a exigir y voy a prohibir el contacto hostil entre las partes.
That means that you may communicate with each other. I believe that there is at least one child between the two of you, correct?
Y le voy a permitir que se comuniquen, pero creo yo que existe un niño en común, ¿no es verdad?
Tres.
Three, okay. And so I'm going to allow you to communicate with each other with regards to the benefit of the children.
Bueno, veo que tienen tres, está bien, por lo tanto voy a permitir que se comuniquen para el beneficio de los niños.
There can be no argument or hostile communication between the two of you.
No pueden haber ninguna discusiones o comunicaciones hostiles entre ustedes.
I'm going to require that you consume or possess no alcohol or non-prescription drugs.
Y le voy a exigir que no posea o ingiera drogas o medicamentos que no sean recetados.
I'm going to require that you possess or control no weapons or firearms.
Le voy a exigir que no sea propietario o que porte armas de fuego o armas blancas.
Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody.
Cualquier arma de fuego o arma blanca en cual usted sea propietario o que usted porte tiene que ser entregada a las autoridades inmediatamente después que sea liberada.
In case the Department of Children and Family Services gets involved in this matter,
En caso que se involucre el Departamento de Niños y Familias en este asunto
and that agency imposes some type of requirements upon you,
y esa agencia le imponga a usted algún tipo de requerimiento,
I'm going to require that you comply with the requirements of the Department of Children and Family.
le voy a exigir que cumpla con los requerimientos que le imponga el Departamento de Niños y Familias.
Anything else, State or Defense?
Algo más, Fiscalía o Defensa.
Nothing from the state.
Nada por parte de la Fiscalía y nada por parte de la Defensa.
Thank you very much.
Muchísimas gracias. And Your Honor, the interpreter can respectfully request the case number for this last defendant, please.
2022 MM 4714.
Thank you, Madam Clerk. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Thank you. Sir, can you please state your name?
Edwin Martinez.
Clarification, Your Honor.
Edwin Martinez.
Edwin Martinez.
Sir, you are here on a violation of probation warrant with regards to a charge of conspiracy to traffic illegal drugs. The judge in this case has set this at a no bond status. I am appointing the Office of the Public Defender to represent you at this time. Thank you, sir.
Madam Clerk, if the interpreter could kindly get the case number, please.
It is 2009 CF 3335B as in boy, O.
Thank you, Your Honor.
Welcome. Do we have any other Spanish interpreter cases? All right, thank you, sir. Interpreter, I think that's all the Spanish cases we have for now.
Thank you, Your Honor. Have a good morning.
Thank you very much. Good morning.
Good morning.
Please state your name.
Stacy McDonald.
You are here with regards to a warrant on violation of probation.
The charges were dropped. It was not me, Your Honor.
I'm appointing the Office of the Public Defender to represent you at this time.
Thank you, Your Honor.
Counsel, do you have anything that you want to talk to her for a second? or-
Yes, Your Honor.
Okay. Counsel, will it help to read the basis of the warrant, or do you?
Yes, Your Honor, please.
It would help? Okay. Ms. McDonald,
Yes.
this is with regards to an underlying charge of a felony battery from a date of December 3rd, 2019.
Correct.
The basis for the warrant is a violation of condition of the order of probation, alleging that you were committing the criminal offense of aggravated assault with a firearm regarding an incident of about July 5th, 2022. There is also another violation with regards to possessing, carrying, or owning any weapon without first procuring the consent of the probation officer. And again, this arises out of an incident from around July 5th, 2022. The judge has set that warrant at a no bond status.
You could have one moment, Your Honor.
Okay.
Yeah. Okay. We did not drop it. Still no.
All right, thank you. You need this? You need this?
You have, yeah, one violation of probation, but it has two violations attached.
All right, thank you, ma'am.
Go ahead.
It sounds good.
All right, please state your name, sir.
Jeffrey Asima.
Wrong person. I don't know why I keep saying this.
All right, and sir, you're here on a charge of aggravated assault with a firearm, domestic violence related. I have reviewed the charging affidavit. I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I do note that we have an individual in the booth. If you would please swear her in.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, or help you God?
Yes.
Please state your name for the record.
Jasmine Borges.
Thank you. State you may inquire.
Good morning, Ms. Borges. How do you know the defendant?
He's my baby father.
Can you move slightly closer to the microphone, please? I can barely hear you.
He's the father of my child.
Do you live together?
It's like a situation right now.
And please forgive me, I'm having a little trouble hearing you. It's maybe just the mic might be a little far away from you. Thank you.
No problem.
Again, I ask, do you live together?
As of right now, yes.
Okay. While this case is pending, do you want to continue living together?
Yes.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
I have no further questions, Your Honor.
Thank you. Defense, any questions?
Defense?
No, I was thinking.
Yes.
No
They
questions.
want to live together.
Okay. Thank you. At this point, I am setting bond at $2,500. I'm going to require that you maintain a separate residence from the alleged victim in the case. I'm going to require that you have no contact whatsoever with the victim in the case. That means directly or indirectly. You cannot speak to her in person. You cannot communicate with her via text, email, any other type of internet or social media platform. No communication whatsoever. That also indicates that you cannot accept communication from her. No communication between the two of you until further order of the court. I'm going to say that if there are any possessions at the victim's residence, you are allowed to return one time with the assistance of law enforcement to pick up any possessions you may have over there. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I will note that the arrest affidavit indicated that law enforcement already picked up one firearm from the scene. But this will also apply to any other weapon that may exist within your control or possession and needs to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the victim at all times. That's 500 feet away from her, her residence, her vehicle, her place of employment, her place of worship, her place of education, and any store that you know she frequents. I believe you all have a child in common.
Yes.
I'm going to, in case the Department of Children and Family becomes involved in this matter, I'm going to require that you comply with any requirements the Department of Children and Family imposes upon you with regards to the children. We're just going to require that you comply with that during this period of time. All right, anything else, counsel? No? All right, thank you, thank you. Do you have a question, you said?
Yes. So
Wait, she has a question.
Yeah, and please, before you ask the question, I just want to make you aware that everything that's being said here is being recorded.
yes. So is there a way like I can tell my side because the police they wouldn't let me have a say so in anything?
There will be, not today though, but there will be an opportunity for you to tell your side of the story. It's probably something that the Office of the State Attorney would want to hear. And State, was she provided with a way to communicate with the State Attorney's Office or with law enforcement with regards to anything she would like to say further?
Your Honor, I only briefly speak with the victims first thing in the morning. I do believe, however, that pretrial contact victims earlier to give them that information. I put it that way because I don't have firsthand knowledge.
Okay, and so what I'm hearing is that you should have or will be receiving information to have further communication with the Office of the State Attorney. All right, any other questions?
So his bond, the 2,000, is that 10% or no?
Is that something what?
Yes, if you go through a bail bondsman, it's 10%. She's asking about the bond.
Okay, yeah. You can utilize the services of a bonding agent.
Okay.
Okay, all right. Any other questions?
No, thank you.
All right, thank you very much.
Mm-hmm. Yes. I'm coming.
Please state your name, sir.
Oh, excuse me, Michael Arthur Keith.
Okay.
Just a minute.
No, it's black. While we're waiting, I will just give you a heads up. I do have a PC challenge. I have a PC challenge on this case.
Oh, okay, thank you. All right, please state your name.
In black.
All right, sir, you are here with regards to a charge of battery by strangulation, domestic violence related. I'm appointing the Office of the Public Defender to represent you at this time. I do see that, huh? Okay.
No, just a little louder.
Can you hear me? Okay. Testing, testing. Can you hear me? You cannot hear me? Testing, testing, testing. Testing, testing. Testing, testing. Testing, testing.
Outside. I'll just try to listen closely. I'm sorry.
Do you use a hearing aid? No? Is the device working? Do we know if the battery is working in the device?
Try.
Testing, 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 testing. Do you hear me somewhat through you hear me better through the speakers in the courtroom?
And I will concentrate. Yeah, it's better through the courtroom.
Okay. I am pumping up the volume here. Is that okay?
Perfect. Thank you, sir.
Okay, you're welcome. Please state your name, sir.
In black.
All right. And sir, you're here with regards to a charge of battery by strangulation, domestic violence related. I'm appointing the Office of the Public Defender to represent you. I do note that there is an individual in the booth. Why don't we hear from the individual first?
Can you raise your right hand, please? Your right hand. Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Dawn Camp, K-A-M-P-F.
All right, thank you. And State, would you like to inquire?
I've been dating this man for,
Hold on a second, ma'am. Please forgive the interruption. This attorney is a representative from the Office of the State Attorney, the prosecuting entity, and I'm going to give her an opportunity to ask you questions.
Yes, sir.
And then I'm going to give the other attorney, who is a representative from the Office of the Public Defender, to ask you questions if they wish, okay?
Yes, sir.
And then you may have an opportunity to say whatever you would like to say, okay?
Thank you, sir.
All right, so counsel?
Good morning, ma'am.
Yes, ma'am.
Are you okay?
Yes, ma'am.
How do you know the defendant?
I've been dating him for a little over 2 years. I lived in his house as of March of last year. We still reside together.
While this case is pending, would you like to continue residing with him?
No, I would like to vacate his property and give the house back to him.
Has something like this happened before?
Once previously.
Are you afraid of him?
I'm afraid of what he could do. When the cops came yesterday, they removed multiple firearms from his house with the help of his brother-in-law. And I thought his first call would be to try to get himself out, not to get firearms out of his house.
I'm so sorry. I'm going to lower this a little bit because we're getting some feedback. But if you would please, ma'am, would you please repeat the last comment you made? Because I had trouble hearing it over because of the problem we're having with the speakers.
I said that I thought his first phone call would be to get out of jail, not to have his brother come pick up all of his money and his firearms.
You're saying that there were firearms in the premises?
Yes, sir. And when the cops left the first time and took Mr. Black, I just left his bedroom door closed, and that was the end of it. When the brother-in-law showed up at Mr. Black's request, he was asked to move the safe, which has money in it, I assume, and all the firearms from the house the cop had his brother-in-law remove them.
All right, and if I may ask, how many firearms?
I'm gonna guesstimate 2 to 3 handguns and 2 to 3 big ones, and it took 2 trips for him to take everything downstairs. There's a gun safe, but I believe it to be empty.
There's a gun safe, but you believe it's empty at this point? Is that what you said?
Yes, all the guns were held in Mr. Black's room, and the gun safe, as far as I know, is empty.
I'm sorry, I'm having difficulty hearing what you're saying. Could you please repeat that again?
As far as I know, the gun safe.
I think it's too loud because
Yeah, it's actually going lower. Go ahead. I'm so sorry. And please forgive us. It's just that, I don't know if you can hear it, but we're getting some feedback on the speakers inside the courtroom. But you're saying that you believe the gun safe is empty at this time?
Yes, sir.
Okay. And you're saying that you believe it was it was his brother-in-law who picked up?
Yes, sir. Mr. Black was apparently on the phone instructing his brother-in-law where to find the keys, where to find the safe, where to find all of the firearms, and the officer who did a standby allowed his brother-in-law to leave with all of these items.
Okay. All right. Thank you for letting us know. Please forgive the interruption, counsel. Please proceed.
That's all right. I have no further questions at this time, Your Honor. Thank you.
All right. And defense, any questions?
No questions, Your Honor. However, may we approach briefly?
It'll be off record, and it's okay to, I just want to let you know that I don't have a way to turn off, to just do a sidebar without turning off the rest, correct? Yeah, so I'm just going to turn it off completely at the request of defense. Okay. You had an issue that you wanted to bring before the court considered anything on the case.
Yes, Your Honor. I'm challenging PC as to the battery by strangulation. Based on this arrest affidavit, there's no mention that the alleged victim could not breathe. In order to have a battery by strangulation, you must knowingly and intentionally impede the normal breathing. She was able to scream, yell. He had his hand on the mouth and at one point on her neck, but it states he did not speak. So at this time, I would ask that you find PC only as to a battery.
State?
Yes, Your Honor, that is the basis, is that it does have to be more, yes, Your Honor, it does have to be more than just placing a hand around a neck. I believe we have another case coming up this morning where a defendant placed a hand around a neck, but it didn't rise to the level of strangulation.
Okay.
So I agree with defense, Your Honor.
Okay, and thank you. All right.
There is a finding, I would ask the court to find, however, that there was domestic violence, Your Honor.
All right. And anything further, defense?
No, Your Honor.
All right, and so I will agree with the two of you. I do not find probable cause for the part of strangulation. I do find probable cause for the charge of battery domestic violence related.
Your Honor, just want to give you the statute then for domestic violence battery. That is 784.03.
All right, thank you. And just for the record, I noticed that the victim is in the booth and she's crying. Is there anything, ma'am, that you wish to say or wish the court to clarify?
I'm trying to pay attention to what you guys are saying, and you're saying that he didn't strangle me, but being choked out multiple times, I would think would be cause for strangulation. Now, I didn't make a police report when the police were there. I still have not made a police report because I was afraid that he would get out right away. My 17-year-old daughter is the one who called the cops, and she is the one who wrote the report or wrote the statement. I just don't know how somebody can do this and it be okay. And
Let me, before you go on to the next point, let me explain that what we're doing here is called an initial appearance. This paperwork is preliminary. It's the beginning. This paperwork will be reviewed by the Office of the State Attorney, and they will decide what charges, if any, will be formally brought against Mr. Blacks. So this is just the beginning, but there's still going to be a review process. There should be an opportunity for you to communicate with the State Attorney's Office before they make a final charging decision in the case, if you wish to make sure that they understand your side of the story.
okay,
Is that a fair representation, State?
Yes, Your Honor.
okay.
Do you understand what I've said?
Yes, you're saying that this is the guesstimation of, so we can write it on paper, and after the state has all details, then they can decide for sure what happens.
They can decide charge they believe that they can prove against Mr. Blocks.
Okay.
So what we're doing here is, under the law, Mr. Blocks is entitled to have a hearing where a court decides if there is probable cause for the arrest, and if there is, then set the terms for release.
Okay. Thank
Okay?
you for explaining it to me.
You're welcome. Or do you have any other questions? No, please
Just like a couple of days to get me and my daughter out of the house.
Well, I mean, I can't tell you how soon he may be released. There's an indication he qualifies for pretrial release. And so pretrial release, if he qualifies, I believe he may be out today.
Your
All
Honor,
right.
two things. Two things. If you could explain what pretrial release is to the victim, and in addition, although someone does qualify for pretrial release, and I actually have no objection to it, you can also add a bond to that, just as an extra layer of protection.
Well, the bond under those circumstances, it's my understanding, helps guarantee his return for hearings. It doesn't guarantee any type of supervision with regards to his conduct while he is out awaiting trial on the case. So, yeah, I mean, so the bonding agent is more or less a guarantee that the person will return for future proceedings.
Yes, Your Honor.
But it doesn't necessarily,
You don't have to charge him any money. I know he'll come back.
I'm so sorry, please say that again?
I said you don't have to charge, if you're gonna let him out, you don't have to charge him any money. I know he'll come back.
Okay. Now, the other thing is that I want you to understand that this is just the beginning of a criminal proceeding. This does not address matters with regards to injunctions against domestic violence. That's a whole separate proceeding. Something that I don't know if it should have appeared in the paperwork that you received from law enforcement. And I just want to make sure that you understand that's a different proceeding that you have the right to seek as well.
I won't be pressing charges. I just want to get away.
Okay, but so what I'm saying is there is something called an injunction against domestic violence. It is not a criminal proceeding. It's more of a civil matter. You have the right to proceed with that. It was given, that information was given to you with the domestic violence packet when the incident occurred.
Okay.
All right, and State, do you know when she might be talking to a victim advocate?
Today I have an appointment at Harbor House.
Okay.
Unfortunately, I was in the emergency room until 4 a.m.
You're saying you have a meeting today with a victim advocate?
Yes, at Harbor House.
Okay, and they're familiar with all of this as well?
Yes, sir.
And so they can also answer a lot of your questions, but I just want to make sure that you understand that your questions are valid and that there are entities that can help try to answer your questions.
Thank you.
And Your Honor, just for the record, my client has somewhere else to stay until she's able to leave the residence. So for 2 or 3 days where she needs to gather her things, he has a place that he can reside until she leaves.
Do you want me to put that in the order?
Is that the same place where his firearms are being stored?
Your Honor, yes, he would, that is where he will be residing. However, Your Honor, he is okay with law enforcement going out to pick up the firearms prior to him leaving. I mean, prior to him staying there. So he will wait until law enforcement gathers the firearms prior to staying there, just so she feels safe.
We appreciate the gesture. Can we have an address?
He doesn't have it on him. That's why I was making the court aware.
Okay.
I don't know if she has the address, but being that, as the state mentioned, law enforcement was there at the time, I'm pretty sure they could locate the address, Your Honor.
Okay. We'll try to fashion some language because it's appreciate both sides voicing their concerns and their willingness to kind of work with this situation. Ma'am, would you know the address where the weapons are at?
I don't know the exact address. It's his sister's house.
His sister's house,
Does he have
okay.
do you have what's the name?
So I'm just thinking out loud, and I would like some input from the state and defense if you have any. I'm wondering if I can put some wording in the order, something to the effect of that within 4 hours of his release from custody is to be accompanied by law enforcement to retrieve his weapons, at this point to be thought to be housed at his sister's house?
Yes, Your Honor, and then we could,
And I'm sorry, the sister's house is in Orange County?
yes, Your
I just want to make sure I have the right law enforcement agency.
Yes. And Your Honor, we could also, if it makes the victim feel safer, we could just have him give a copy of the receipt that he's gonna get from law enforcement to the clerk's office.
All right.
Just have it filed so that, you know, he did turn over the weapons.
Okay, now, this may be all aspirational because it may take a few hours for him to get out. And then by the time law enforcement kicks in and whatnot, it may not be that he's able to hand in a receipt until tomorrow morning.
Yes, Your Honor, so the proof that he's turned over the firearms, I would give him 24 hours at least to turn it over to him, just depending on when he gets out.
Okay. And then there's also been an indication that he's willing to stay away from the shared residence for 2 days. Would that be enough time for you to move out, ma'am? Let me put it this
I
way.
have my appointment with Harbor House today. I get paid tomorrow. We're putting everything into storage and we're going to try to be out by Saturday at the absolute latest. I really am trying. Really.
Okay, you're going to be out by Saturday.
I'm hoping, I'm praying, I will do my absolute best.
Your Honor, while defense is speaking, I only have one concern. You said that he, within 4 hours of his release, he used to go with law enforcement. My only issue is if law enforcement isn't available or they cannot make it, is the language going to reflect that he's not going back to jail if law enforcement is the one who's not available?
Correct.
Okay.
Yeah, no, it's not, and I don't know if anyone here can help me with this, but the idea is that immediately upon his release, he's going to seek the assistance of law enforcement in order to help him retrieve these weapons and give him a receipt. But obviously, if law enforcement, is involved in some other type of emergency situation and cannot help him, it's, he's just going to have to wait until they're available. Because the wording is within 24 hours of release to give file a receipt with the clerk's office that the weapons are in the custody of law enforcement. All right, and so this is all something kind of relatively new. And so it's not a proven method. All we can do is aspire to try to get this done. Yes, ma'am?
He can't come to the house for that 24 hours, can he?
I'm so sorry?
He can't come to the house for that 24 hours, can he?
She's asking if he could go to the house within those 24 hours, and no, we're not asking that. This is for the firearm, so it would be at his sister's house.
Right. I will be ordering that he maintain a separate residence from you. Now, if you are no longer at that residence and you're planning on moving out, I can put in wording to the effect of, I don't want either one of you to be homeless as a result of this.
He will be staying with his sister. She has a big house and an extra room. Me and my kid are gonna go to a homeless shelter as soon as I can get my stuff out and get my paycheck.
Okay, and so,
I'm not trying to keep him out of his house.
okay, and so what I'm looking at is possibly putting into the paperwork that she will have vacated the house by Saturday, 12 noon, and he can return to this residence after Saturday at 12 noon.
Your Honor?
Yes.
Your Honor, I would ask that you just put in an order for separate residence. It is understood that if The victim is still there, the defendant cannot return. And I ask that only because unfortunately, things do happen. So if she cannot move out, but the order says that he can move back in at 12 o'clock on Saturday, they have to come back to court. It's an uncomfortable situation. So if you just leave it at separate residence with the understanding, if the victim is present, defendant cannot return home.
Defense?
Correct.
Okay, thank you.
I appreciate.
All right.
That was a lot.
Anything else?
No, Your Honor.
Your Honor, can we just clarify what the conditions of release are?
Yeah, I'm going to get that, but I appreciate the conversation beforehand because it helps me. And so at this point, I am going to agree that he be released through the pretrial release program. I'm not going to set a monetary bond, as that would just guarantee that he would return back to courts, and there's no indication that he has any failure to appear ever. I'm going to require that he maintain a separate residence from the alleged victim in the case. I'm going to require that you may return one time with the assistance of law enforcement to retrieve any personal belongings. Again, we don't know what might happen. We know the intent is for you to move out Saturday and for him to be able to go back in, but we don't know if that's going to happen or not. At least give the opportunity, if that does not occur, to return one time with law enforcement to retrieve personal belongings. I'm going to require that you have no contact whatsoever, directly or indirectly, with the alleged victim in the case. That means that you cannot speak to her in person. You cannot communicate with her by text, email, any type of internet or social media platform. And you cannot have a third person communicate on your behalf with her. That also means that you cannot accept any communications from her. I'm going to require that you consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. I'm going to require that within 4 hours of your release from custody, you seek the assistance of law enforcement to retrieve weapons that are your weapons that are presently housed at your sister's house in Orange County, Florida. And that within 24 hours of your release, you file with the clerk of court a receipt from the sheriff's office indicating the weapons that they have taken possession of and will safekeep for you.
If available, as long as law enforcement is available, Your Honor.
As long as law, well,
I don't know how we're going to word it, but.
yeah, well, so we said it's within 4 hours, he's going to seek the assistance. And yeah, so within 4 hours, at least be in communication with the law enforcement to say, hey, this needs to get done. The judge ordered it. They're going to look at the court file. We have to give them time to look at the court file and say, yeah, the judge ordered Orange County Sheriff's Office to assist Mr. Blacks in retrieving these weapons from his sister's house in Orange County. So that'll be in there, in the paperwork, in order to sheriff's office. So I'm ordering them to do it. And so that's also something that perhaps you can help him with the wording when he contacts the sheriff's office and say, hey, the court is ordering me to do this and is ordering the sheriff's office to do this. But I am ordering him to relinquish all of his weapons to the sheriff's county's office for their safekeeping. I'm ordering them to give you a receipt for these weapons and for them to house these weapons safely for you until further order of the court. All right? Hopefully that wording will help everyone here. I'm going to require that you maintain a distance of at least 500 feet away from the victim at all times, her residence, her place of employment, her vehicle, her place of worship, her place of education, and any stores that you know she frequents. I'm going to require also that you have no contact with any witness in this case, directly or indirectly. Did I address all?
Yes, I believe so, Your Honor.
Yes, I was just going to ask, Madam Clerk, is it downtown he has to drop it off, or could he drop it off here as well? Okay, thank you. Just to the clerk's office downtown.
And if there's any tweaking of language that's needed, you know, I'll be here all week, so by all means, please, anyone, let me know, so we can try to, we know what we're trying to accomplish, we just need to make sure the paperwork reflects it. Ma'am, do you have any other questions?
You said he's not allowed to contact the witness. I would just like him to understand that the witness would be my daughter, Harley.
Correct, he's to have no contact with your daughter.
Thank
She's a witness to this event.
Thank you.
All right, anything else, ma'am?
No, sir.
All right, thank you for being here today.
Thank you for explaining to me how it goes.
You're welcome, ma'am. Thank you, Mr. Blacks. If you'll hold on a second. Oh. Monday, okay. Mr. Blacks, hold on. Mr. Blacks, Mr. Blacks, Mr. Blacks, hold on a second, please. Hold on a second, please. Madam Clerk has indicated to me that if I give you 24 hours to submit a receipt, that is going to fall possibly into the weekend, and the clerk's office is closed.
Oh, okay. I
And
didn't
so I'm going to give until Monday,
file the receipt.
9 o'clock in the morning. So file it as soon as you can, but if it's the weekend, then file it no later than Monday at 9.
Let's do it on Monday. So he's just giving you extra time, just in case.
Appreciate it.
All right, thank you. Please state your name, sir.
Keegan Fleming.
Thank you. Sir, you are here on a couple of matters. Bear with me as I read through these. You are here on 2 charging affidavits. First is an affidavit with charges of count 1, burglary of an occupied conveyance, count 2, robbery by sudden snatching, count 3, grand theft, 3rd degree, count 4, kidnapping, dating violence related, count 5, false imprisonment, dating violence related, count 6, battery, dating violence related. There is a second charging affidavit with the following charges: count 1, extortion, count 2, sexual cyber harassment, count 3, tampering or harassing a witness, domestic violence related, and count 4, violation of a domestic injunction. I am appointing the Office of the Public Defender to represent you. I have reviewed these affidavits and I find probable cause for the charges. Is there any comment from the State or Defense before I recite terms of release?
Not at this time, Your Honor.
No, Your Honor.
Thank you. All right, so with regards to case number 2022CF6234, burglary of an occupied conveyance, I'm setting that at $1,500. The charge of robbery, sudden snatching, I'm setting that at $1,000. Grand theft, 3rd degree is set at $500. Kidnapping, I'm setting that at $5,000. False imprisonment, $2,500. Battery, $5,000. With regards to the kidnapping, false imprisonment, and battery, I'm also going to require that you have no contact, directly or indirectly, with the alleged victim in the case. That means that you cannot talk to the person directly, you cannot text them, you cannot email them, you cannot use any type of internet or social media platform to communicate with her, and you cannot try to communicate by a third person. You can also not accept any communications from her as well. You must maintain a separate residence from the victim. If applicable, you can return one time with law enforcement. I believe they live separate, but if applicable, you can return one time if there's any personal possessions of yours at the victim's residence.
Can I say something when you finish?
Yes, but just to let you know that everything that's being said in here is being recorded, and if you say something, it could be used against you. I will be asking defense attorney, since I've appointed the Office of the Public Defender to represent you, I would ask that you clear any questions through the attorney first. All right, may I proceed, or is there a question?
No.
All right, thank you. And again, with regards to the conditions on the last three charges, it was maintain a distance of at least 500 feet away from the victim. That's 500 feet away from her place of residence, her vehicle, her place of employment, her place of worship, her place of education, and any store that you know that she frequents. I'm going to require that you possess or consume no alcohol or non-prescription drugs, and that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. With regards to case number 2022CF6541, the charge of extortion, I'm setting bond on that at $2,500. On the charge of sexual cyber harassment, I'm setting bond at that at $2,500. On the charge of tampering or harassing a witness, I'm setting that at $2,500. And with the charge of violation of a domestic injunction, I'm setting that at $5,000. I'm also going to set the same conditions as I stated before with regards to having no contact with the victim.
OPD just call her at my house. Y'all putting all this bond on me, bro. How I'm gonna get out with all this bond? I got a job, I got work, I got kids, I got rent to pay. How I'm gonna get out with all this bond that y'all putting out on me, bro? She just was at my house. The police just called her at my house.
I understand the
That's
frustrations.
crazy, bro. How I'm supposed to get out with this bond like this? Like
I'm not,
How I'm gonna get out?
okay. And counsel, if I may just continue then?
Yes, you may, Your Honor.
So with regards to that second case, I'm also imposing the same conditions of no contact, maintain separate residence, maintain 500 feet away from the alleged victim, not to consume or possess alcohol or non-prescription drugs, not to possess or control any weapons or firearms. Any weapons or firearms within his control or possession are to be handed over immediately to law enforcement upon his release from custody. Anything
Your
else, State Defense?
No, Your Honor.
Nothing from the state.
All right, thank you. Please state your name, sir.
Good morning, Your Honor. My name is Michael Arthur Keith.
Good morning, sir. And sir, you are here with regards to charge, is this for me?
It's just the pre-trial.
You're here with two charges. First charge is a charge of aggravated assault, domestic violence related. Second is a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I am appointing the Office of the Public Defender to represent you. With regards to count one, aggravated assault, domestic violence related, I'm setting bond on that matter.
Your Honor, please, can I say something?
Hold on.
Nothing.
Sir.
I didn't do nothing.
No, hold on.
I'm sorry, sir. I'm sorry.
No problem. I just.
So sorry. I just didn't do nothing. I got to.
Yeah. And sir, let me just explain that everything you say is being recorded and can be used against you. That's why we were all trying to stop you from speaking. Not that we wanted to be disrespectful. It's just that we want to make sure that if you say anything, that I would prefer if you run it by the attorney standing next to you first.
Yes, sir.
Okay? And so I've been made aware that there is a person in the booth, and so we're going to hear from that person first, okay?
Thank you, sir.
All right. Please proceed.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Angela Lewis.
And ma'am, this attorney is from the Office of the State Attorney, and she's going to be asking you some questions.
Good morning, ma'am.
Morning.
How do you know the defendant?
Through a friend.
I'm sorry?
Through a friend.
Can you step slightly closer to the microphone? I can barely hear you.
Through a friend.
And you can pull the microphone closer to you as well. Thank you.
Do you live together?
Yes, we do.
While this case is pending, do you want to continue living together?
Yes, ma'am.
Has something like this happened before?
No, ma'am.
Are you afraid of him?
No, ma'am.
Were drugs or alcohol involved in this incident?
Alcohol.
Okay, thank you. I have no further questions, Your Honor.
Defense, any questions?
No questions, Your Honor.
All right. We appreciate your showing here today. Before we proceed, do you have any questions?
I don't have no question, but I was asking to take in consideration for my fiance to get released today because I have work and he helps me with my disabled son. He helps me with the feeding because he has medical issue and he needs feeding. And I'm unable to do it by myself if I have to go to work.
Okay, thank you. All right, and so based upon what the individual stated, is there any further questioning by the state or defense of this individual?
Nothing from the state.
No questions, Your Honor.
All right, thank you. And so with regards to the charge of aggravated assault, domestic violence related, I'm setting bond at $2,500. With regards to the charge of battery, domestic violence related, I'm setting bond at $2,500. I'm going to require that there be absolutely no contact between you and the alleged victim in the case. That means that you cannot talk to her. You cannot communicate via text, email. You cannot use any type of internet or social media platform to communicate with her. You cannot have a third person try to communicate on your behalf, and you cannot accept communications from her. I'm going to require that you maintain a separate residence, that you may return one time with the assistance of law enforcement to pick up personal possessions. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That is 500 feet away from her person, her residence, her place of employ, her vehicle, her place of worship, her place of education, and any store that you know that she frequents. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Then I have been made aware that you are out on 2 other charges. One of those charges being aggravated battery with a deadly weapon. On both of these matters, those would be the cases 2022 CF 2022 CF 16556 and 2022 CF 15252. I'm going to revoke those releases and set them at a no bond status. Right. Anything else from the state or defense?
No, Your
Nothing
Honor.
Nothing from the state.
I think he has Leon Cheek for the out on bond.
Okay.
Given the victim's testimony, Your Honor, would you be willing to revoke and double as opposed to holding him at no bond?
No, the indications are that he was out on release on a very similar charge. So I'm just trying to keep these individuals apart until they get further assistance. Ma'am, you have a question?
Can I say something?
What is the question?
Well, I don't have a question, but he has not hurt me, so why isn't?
You will have an opportunity, and if you were hearing the prior conversations with other individuals, you have an opportunity to communicate with the Office of the State Attorney if you want them to have further information from you.
Okay.
And anything you may want to add to the situation or clarify, or any wishes that you have, okay?
Okay, so he could, so there's no bond?
So I set bond on the case that brought him here today, but he was out on 2 other cases.
Right.
And so on those, I revoked his release and set those at a no bond status
Because of his other charge?
because of the charge that brought him here today.
Okay. Okay,
Okay, does that answer your question?
yes,
All right, any other questions?
that's it.
All right, thank you very much. Please state your name.
Irene Allen Brandon.
Is there anyone here on that case? No. All right, you're here on a charge of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I am appointing the Office of the Public Defender to represent you at this time. I am setting, I see that she qualifies for pretrial release. I'm going to agree to that and have you released through the pretrial release program. I'm going to require that you maintain a separate residence from the alleged victim in the case, that you have no communication, no contact with the alleged victim in the case. That means that you cannot speak to her in person, cannot text her, email her, telephone her. You can't have any type of contact via internet or social media platform, and you cannot ask another person to communicate on your behalf. You must maintain a distance of at least 500 feet away from the victim. That's 500 feet away from her person, her residence, her vehicle, her place of employment, her place of worship, her place of education, and any store that you know she frequents. I'm going to require that you consume or possess no alcohol or non-prescription drugs, and that you can possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. There's a possibility that the Department of Children and Family Services may become involved in this matter. If DCF becomes involved and if they require you to follow some type of plan, I'm going to require that you follow the requirements of the DCF, okay? Think I've covered all bases. Anything else, State or Defense?
Nothing from the state.
All right, thank you, ma'am. One-time return with law enforcement if applicable. If I didn't, yeah, we'll include that. Thank you. Please state your name.
Maranatha Divinard.
And you are here with regards to 2 counts. Count 1 is battery, domestic violence related. Count 2 is disorderly conduct. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. With regards to this matter, I see that you qualify for pretrial release, and I'm going to release you through the pretrial release program. I'm going to require that you maintain a separate residence from the alleged victim, that you have no contact directly or indirectly with the alleged victim. That means that you cannot talk to them in person, text them, call them, email them, have any type of internet or social media contact with them, and you cannot have a third person try to communicate on your behalf. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to allow you to return one time with the assistance of law enforcement to retrieve any personal belongings that may be at the residence. And in case the Department of Children and Family Services becomes involved in this matter, and if they require you to take certain steps or submit you to a certain plan, then I'm going to require that you comply with the requirements of the Department of Children and Family Services. I think I did everything. Anything else, State Defense?
Thank you, Your Honor.
All right, thank you, ma'am.
No, Your Honor.
No, Your Honor.
Yes.
Sorry.
You drink coffee?
Try not to.
That's good. Please state your name.
Clarissa Doyle.
You're here with regards to a charge of battery domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I'm going to set bond at $1,500. I'm going to require that you maintain a separate residence from the victim in the case, that you have no contact whatsoever with the victim, that is directly or indirectly. That means that you cannot speak to them in person, you cannot telephone them, email them, text them, try to communicate via any type of internet or social media platform, and you cannot have a third person try to communicate with them on your behalf. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That's 500 feet away from their person, their residence, their vehicle, their place of employment, their place of worship, their place of education, and any store that you know that they frequent. Anything else, State or Defense?
No, Your Honor.
No, Your Honor.
All right, thank you, ma'am. Please state your name.
Jolene Hill.
And you are here with regards to a charge of battery domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I see that you qualify for the pretrial release program, so I will agree to have you released through the pretrial release program. I'm going to require that you maintain a separate residence from the alleged victim in the case, that you have no contact directly or indirectly with the victim in the case. That means that you cannot speak with them directly, you cannot telephone them, text them, email them, or try to communicate via any internet or social media platform. And you cannot have a third person try to communicate on your behalf or accept any communications from them. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the victim. That means 500 feet away from their person, their residence, their place of employ, their vehicle, their place of worship, their educational institution, and any place, any store that you know that they frequent. All right? Anything else from the State or Defense?
No, Your Honor.
No, Your Honor.
All right, thank you, ma'am.
Your Honor, Ms. Hoffman is a refusal.
All right, thank you. And did I? Oh. Okay. Bear with me a second. Okay. Oh. Got it, thank you. Thank you very much. Okay. With regards to the case of Madge Hoffman. This is with regards to a charge of battery domestic violence related. I'm appointing the Office of the Public Defender to represent them at this time. I have reviewed the charging affidavit and I find probable cause. Might this individual still qualify for mental health pretrial release? And if we don't have a clear answer right now, I can set a monetary amount or mental health pretrial release if that,
You can just have them screen, Your Honor.
okay. And so I'm going to set bond at $1,500 or mental health pretrial release if she qualifies. I'm going to require that she maintain a separate residence from the alleged victim, that she have no contact directly or indirectly with the alleged victim. I'll skip the recitation of what that means, as I know counsel has heard me say it at least 200 times this week. I'm going to require that she consume or possess no alcohol or non-prescription drugs, possess or control no weapons or firearms. Any weapons or firearms are to be handed over immediately to law enforcement upon their release from custody, and also maintain a distance of at least 500 feet away from the alleged victim, their residence, their vehicle, their place of employ, their place of worship, the place of education, and any store the victim knows that they frequent. I do understand that she is presently out on a charge of battery on a Leo and was released on mental health pretrial release. I'm going to leave that intact.
No, she wasn't released on mental health PTR. It was regular PTR.
Just regular PTR. And I'm sorry, when I looked at that file, I thought I had seen it. I thought I saw mental health pretrial release in that file.
That's what I thought as well. It said something about taking meds and mental health. That's why I thought it said the same thing. It was confusing.
But you're saying that the system indicates she is not out? It's just straight PTR on that other case? Okay, well, I'm not going to, hopefully it is mental health pretrial release, but if not, hopefully she'll qualify for mental health pretrial release in this case.
Oh,
But I'm not going to take action on the matter that she's out on.
thank you, Your Honor. I was pretrial with mental health conditions.
Your Honor, McManus is behavior.
And I will waive the appearance, Your Honor.
All right, thank you. So I can dump this, right? Oh, wait.
You're not,
I'm taking no action, right? So
you still have to mark it.
you mark it.
I'm not sure. We'll check it at the end.
Okay. With regards to the case of McManus, I was informed that that is behavior. Is that correct?
Yes, Your Honor.
Thank you. That is a charge of battery, dating, violence related. I've reviewed the charging affidavit, find probable cause. I'm appointing the Office of the Public Defender to represent him. I believe, defense, did you already say you were waiving his appearance?
Yes, Your Honor.
All right, thank you. With regards to McManus, I'm setting bond at $2,500. Maintain a separate residence from the alleged victim. No contact directly or indirectly with the alleged victim, as I've stated before in the other cases. Can return one time with the assistance of law enforcement to retrieve personal belongings. Possess or consume no alcohol or non-prescription drugs. Possess or control no weapons or firearms. Any weapons or firearms are to be handed over immediately to law enforcement upon their release from custody. Maintain a distance of at least 500 feet away from the victim. That means their person, residence, vehicle, place of employ, place of worship, place of education, and any store they are known to frequent. Please state your name.
Hazel Mitchell.
You're here with regards to a charge of battery domestic violence related. I have reviewed the charging affidavit and I find probable cause. I am appointing the Office of the Public Defender to represent you at this time. I'm going to impose the following bond in the amount of $1,500. You are to maintain a separate residence from the alleged victim. You are allowed to return one time with the assistance of law enforcement to retrieve any personal belongings. I'm going to require that you have no contact directly or indirectly with the alleged victim in the case. That means that you cannot talk to her in person. You cannot call her, text her, email. You cannot use any type of internet or social media platform to communicate with them. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm also going to require that you maintain a distance of at least 500 feet away from the alleged victim. That's 500 feet away from them as individually, from their residence, their vehicle, their place of employ, their place of worship, their place of education, and any store that you know that they frequent. Anything else from the state or defense?
No, Your Honor.
No, Your Honor.
All right, thank you, ma'am. If it's not, you'll let me know. Okay. Please state your name, sir.
Mahmoud Mousli.
Thank you. You're here on a charge of battery domestic violence related. And I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I see that we have two individuals in the booth. If you'll please swear them in.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your names for the record.
Ali Mousli.
Ala Mousli.
Thank you. Now, I'm going to give the attorney from the Office of the State Attorney an opportunity to ask you questions. Then I'll give the defense attorney an opportunity to ask you questions. And if you have something that you want to make the court aware of, then we'll give you an opportunity to say things as well, okay? And so, State?
Thank you. Mr. Ali Mousli, how are you related to the defendant?
That's my brother.
Do you live together?
Yes, ma'am.
While this case is pending, would you like to continue living together?
Of course.
As something like, are you afraid of him?
No.
I have no further questions, Your Honor.
Thank you.
All right, and defense, any questions?
No questions, Your Honor.
All right. And so I see that there's another individual here and,
I'm his uncle. I'm the uncle, sir.
all right. Is there anything you'd like to make the court aware of?
No, it's just what happens between brothers sometimes, and that's it, sir.
All right, thank you. All right. Any comments from the state or defense before I impose release terms?
Your Honor, I would just ask for no hostile contact and pretrial release, given that he does qualify.
And state, any
From the state.
okay. And so at this point, you do qualify for the pretrial release program. I will agree that you will be released through the pretrial release program, required that you comply with all the conditions there. I'm going to require that you have no hostile contact with the alleged victim in the case. All right, and so that means that you can communicate, but as soon as there's any hostile communication or contact, if anyone calls the police, this is going to be a much more serious situation for you, okay? I'm going to require that you consume or possess no alcohol or non-prescription drugs. And so it probably would be wise, and for the record, I'm looking at the brother in the booth and the uncle, to make sure that there be no alcohol or non-prescription drugs in the residence.
It's against our religion, sir, so either way, we don't drink or...
Thank you for letting us know. All right. And so I'm going to, no hostile contact, PTR, no alcohol, non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. Okay?
Sir.
Anything else from the State or Defense?
No, Your Honor.
No, Your Honor.
All right, thank you, sir. Thank you all for coming.
Thank you, sir.
Thank you.
Please state your name.
Mark Pocket.
And, sir, you are here with regards to a charge of battery, dating violence related. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I see that there is an individual in the booth, and can you please swear her in?
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Please state your name for the record.
Carolyn DeCoco?
And, ma'am, you've seen how this works with the other cases?
Absolutely.
You need me to explain anything about what's going to happen?
No, sir.
All right, thank you. And state you may inquire.
Thank you. Good morning, ma'am.
Good morning.
How do you know the defendant?
He's my boyfriend for 12 years.
Do you live together?
Yes, ma'am.
While this case is pending, do you want to continue living together?
Yes.
Has something like this happened before?
No, not. The man I seen was the devil. No.
Okay. Were drugs or alcohol involved in this incident?
Yes, ma'am.
I have no further questions at this time, Your Honor. Thank you.
Defense?
Oh, no questions, Your Honor. Just wanted to make sure.
Is there anything else you would like to make the court aware of?
I have a court ex parte that I'm working on that for him to go straight into rehab. I would hope that the court can help me with that and honor that he leaves the facility here and goes into a rehab facility.
And please understand that I don't have the ability to do that.
I know, that's why I went after the ex parte. Yes.
Okay. Anything else, State or Defense?
Nothing from the state.
Nothing from defense, Your Honor.
He qualifies for pretrial release, and so I'm going to agree that he be released through the pretrial release program and that he comply with the conditions of the pretrial release program. Under the circumstances, I'm going to require that you maintain a separate residence from the alleged victim. We'll give you the ability to return one time with the assistance of law enforcement to pick up personal belongings. I am going to require that you have no contact with the victim directly or indirectly. That means that you cannot talk to her directly, you cannot telephone her, you cannot email her, text her, use any type of internet or social media platform to communicate with her. You must maintain a distance of at least 500 feet away from her residence, her vehicle, her place of employment, her place of worship, her place of education, and any store that you know she frequents. You are to consume or possess no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I think I addressed all issues. Do you have any questions, ma'am?
So with the ex parte, do I bring it up here? Because I'm supposed to pick it up. Do I bring it up here and have you guys serve it to him so he can be put into?
That is something beyond my ability to respond to. I
was told that's what I could do. I just wanted to just reiterate it with you.
I understand.
Yeah.
I am not completely sure what process you are going through and what stage in that process you are at. I don't know if it's something that perhaps the state attorney may want to comment on or guide on, or,
Generally speaking, Your Honor, anytime that something has to be served on a defendant, it has to be done formally, be that through the sheriff's office or through a process server. So I do not believe that she would be able to serve it.
No, I
but-
was told to bring it here for you guys to give it to him to sign over so then he can get released to get help.
well, normally if it's again, I'm at a loss to know what it is that you're talking about.
Yeah.
But if it is something that requires what's called formal process on an individual, usually that is done by law enforcement or by a process server. If the individual is in custody, then it is usually done through the system where it would be given to law enforcement. Law enforcement would then hand it to corrections or would come directly and serve him while he is still in custody.
Absolutely, that's what he said, yeah.
So what I would, so I would recommend, I mean, you have good questions.
Yeah.
I would probably go down, is the clerk downstairs, first floor? No, is there any representative down there? Just inmate records? Is there any representative from law enforcement on the first floor? Okay.
I was told if I bring it to the window downstairs and I take it to the window,
Okay.
I have to sign a piece of paper, then they bring it to him, he signs it, and then I
Okay,
get
and
my
that's
copy.
fine. Follow that process. It's just that that's a process separate from us.
Right,
But that sounds very logical, what you were told.
okay.
And by the way, that was an adorable baby you were shaking out there. I mean, you were rocking, not shaking, you were rocking.
I was trying, just keep him calm so you guys can keep your courtroom quiet and, you know.
That's a big baby.
He was very, he was so sweet though. He was such a, he's so gentle. He was very nice. Thank
Well,
you.
I noticed because of his size.
Yeah.
And so, yes, very, very cute.
Thank you.
All right, well, and you did an excellent job of
I was trying
keeping
to
him
help a
quiet.
mom.
Yeah.
Mom to a mom, we got to try to help each other.
Okay, well, then, thank you very much for
Thank you,
coming
you
here
guys.
today.
You have a pleasant afternoon.
Thank you.
Thank you.
Please state your name.
Shaw.
You're here with regards to a charge of battery, domestic violence related. I have reviewed the charging affidavit and I find probable cause. I'm appointing the Office of the Public Defender to represent you. Any comment from the State or Defense at this point? There's no one left in the waiting room?
I would just ask for a pretrial release, Your Honor.
All right. And so at this point, I'm going to note that you qualify for the pretrial release program. I'm going to release you through that program and require that you follow the requirements of that program. I'm going to require that you maintain a separate residence from the alleged victim in the case. You may return, if applicable, one time with law enforcement to pick up personal belongings. I'm going to require that you have no contact with the alleged victim. That means that you cannot talk to them. And go ahead, sign first, and I'll keep on explaining. So you are not to communicate with them, you can't talk to them, can't call them, can't text, email them. You cannot use any type of internet or social media platform to communicate with them, nor use a third person to communicate on your behalf. I'm going to require that you consume or possess no alcohol or non-prescription drugs, that you possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim, from their residence, their vehicle, their place of employment, their place of worship, their place of education, and any store that you know that they frequent. All right, anything else, State or Defense?
No, Your Honor.
All right, thank you. Please state your name, sir.
Darius Walker.
And sir, you are here on a warrant with regards to a charge of stalking, dating, violence. I'm appointing the Office of the Public Defender to represent you. At this time, I'm going to place bond at $2,500. You are to have no contact whatsoever, directly or indirectly, with the alleged victim in the case. That means that you cannot talk to them in person, you cannot telephone them. And go ahead and sign, and I'll keep on explaining after you sign. So you can't talk to them in person, you cannot call them, text them, you can't email them, you can't use any type of internet or social media platform to communicate with them, and you cannot have a third person communicate on your behalf. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That's 500 feet away from their person, from their residence, their vehicle, their place of employment, their place of worship, their educational institution, and any store that you know that they frequent. Bear with me a second, then I'll give you an opportunity to ask a question, but because everything is being recorded, I'm going to have you clear it through the attorney first, okay?
Sir.
I'm going to, I said no contact, going to require that you consume or possess no alcohol or no non-prescription drugs, that you control or possess no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over immediately to law enforcement upon your release from custody, okay? And go ahead, counsel.
Thank you, Your Honor.
All right, thank you. That's it. Thank you, sir. Please state your name.
Paige Wilson.
All right, you are here on a charge of battery, domestic violence related. I have reviewed the charging affidavit, and I find probable cause. I'm appointing the Office of the Public Defender to represent you at this time. I am going to release you through the pretrial release program, so I'm going to require that you comply with the conditions of the pretrial release program. I'm going to require that you maintain a separate residence from the alleged victim in the case. You may return one time with law enforcement to retrieve personal belongings. I'm going to require that you have no contact directly or indirectly with the alleged victim. That means that you cannot talk to them in person, you cannot telephone them, you cannot telephone them, you cannot text them, email them, or use any type of internet or social media platform to communicate with them, and you cannot have a third person try to communicate on your behalf. I'm going to require that you maintain a distance of at least 500 feet away from the alleged victim. That's 500 feet away from them, from their residence, their vehicle, their place of employment, their house of worship, their educational institution, and any store that you know that they frequent. There is a possibility that DCF may become involved in this matter. If they do, and if they put any requirements upon you, I'm going to require that you comply with the requirements placed upon you by the Department of Children and Family Services. Is there anything else from the State or Defense?
Your Honor, I may have missed it. Did you say no drugs or alcohol?
If I didn't, let me say it. You are to possess or consume no alcohol or non-prescription drugs. You are to possess or control no weapons or firearms. Any weapons or firearms within your control or possession are to be handed over to law enforcement immediately upon your release from custody.
Your Honor, for clarification, is there one victim or two victims?
see one. State, do you see a second victim here?
Your Honor, there are two listed, and there is an allegation of the defendant also striking
That's the-
Nicole
Yeah, yeah, okay.
Garcia.
Thank you. So there are two victims, so this would involve both victims, what I just said. Do you understand what we've said? So there's two alleged victims, so all of the conditions I just recited to you is going to pertain to both victims. Do you understand what I've said?
Yes.
All right. And do you have any other questions to run through the attorney?
Yes. Yes, I do.
Go ahead.
Thank you, Your Honor.
Anything else, counsel?
Nope.
All right. Thank you then. Please state your name.
Jason Correa.
Mr. Correa? Correa.
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 Yes.
So it's not Correra. And sir, you are here with regards to an out-of-county warrant. It is from Miami-Dade, and this is a felony warrant regarding sale or delivery. The judge has put that at a no-bond status. Do you understand what I have said?
Okay, but
Everything you say is being recorded and can be used against you, so I want to make sure that you understand that before you say anything.
I was unaware of this.
Okay, and as a friend of the court, the Assistant Public Attorney just wishes to screen that question beforehand, okay?
Thank you, Your Honor.
All right, so is there anything the court can clarify or for him?
He was asking for a bond, Your Honor, but I was explaining the process.
Yeah, and just as the attorney has probably explained to you, this is outside our control because it belongs to a separate county. So you will be transported to that county. But what happens is when someone is taken into custody here, we need to let you know why. And so the reason you were taken into custody is because of this warrant from Miami. But we have very limited information other than there's an active warrant. And so once you get to Miami, you'll have a lot more information, okay? Hold on.
He's stating the same thing, Your Honor. He's stating he has custody of a child, but as I explained, even though all of those factors may be true, you cannot change the out-of-county warrant, Your Honor.
Right, I have no ability to,
Medical, I haven't seen medical yet.
hold. And again, it's not that we mean to be rude, it's just that everything you say is being recorded. But what's going to happen is you're going to be transported to Miami. And anyone know how soon that'll occur?
No, Your Honor.
No? Okay.
Muscle spasms and everything, that's why I was worried about Miami.
Okay, and that's something that you can pass through medical here at corrections. So you should be screened by medical. If you haven't, you should be able to request it, and then make them aware of any conditions that you have, any medications that you require.
I've been trying to do that all night.
All right, thank you, sir. Please state your name.
Tony Alfredo.
And I'm sorry, what's the last name?
Feta, F-A-T-A.
Thank you. And sir, you are here with regards to an out-of-county warrant from Brevard County with regards to an underlying matter of battery domestic violence related by strangulation. The judge has set that at a no bond status. I'm also aware that you are out on bond on two matters here in Orange County.
And Your Honor, I would ask that you take no action, given the fact that with the out-of-county warrant, we have no access to that warrant, so I can't see the dates of when that warrant, when that alleged crime occurred. So we don't know if it was before the out on bond or after, which is why we normally ask that no action is taken on the out on bond.
And so I'm going to be a bit more careful. And I'm going to revoke on those two other cases and set it at a no bond status. Thank you.
And yes.
There's an indication that he has private counsel on those matters.
Oh, on the out on bonds. Okay.
Yeah, he's got an indication. He
Okay,
had
then you're fine.
Attorney Bigney
So you got to call him.
representing.
Call your friend.
Yeah, your attorney will know what to do,
Thank
very
you.
experienced attorney. Okay.
Go ahead, Jose. Put your mask on.
Please state your name, sir.
Jose Hormazabo.
And sir, you are here with regards to two out-of-county warrants from Seminole County from charges of violation of probation, grand theft, 2 counts. The judge has set this at no bond status. Do you understand what I have said?
Yes.
All right, thank you, sir.
When do they move me to Seminole?
When will they move you to Seminole? I don't know, but I imagine it won't take that long because you're just nearby. Whereas Miami, the other individual is further out, that's going to require some transportation. It's my understanding that Seminole is rather quick. All right, thank you, sir.
Your Honor,
Yes.
Robbie is a refusal.
Is a refusal?
Yes, sir.
Okay. And for the record, he is here on a matter of an out-of-county warrant from Osceola County with regards to a charge of unoccupied, unarmed conveyance or burglary. The judge has set that bond at $2,500. Please state your name.
Paul Boyd.
Sir, you are here on a capias with regards to 2 counts. Count 1 is burglary of a dwelling. The judge set bond on that at $5,000. Count 2 is grand theft 3rd degree. The judge set bond on that at $150. I'm appointing the Office of the Public Defender to represent you on those matters. You also have a warrant with regards to a violation of probation on an underlying charge of burglary, assaulting, and the judge has set that at a no bond status. All right, sir? He has conditions listed on the warrant. All right, with regards to the first matter, the capias. Okay, thank you. All right, and sir, continuing with the new charge, the warrant on the burglary of a dwelling and grand theft, the judge put conditions on the warrant. Madam Clerk is asking me to recite them on the record. They will continue even because they're still on the warrant. But as clarification, the warrant does indicate that you are to have no contact directly or indirectly with the victim, co-defendant, or witnesses in the case. You are to have no hostile or violent contact with the victim. You are to maintain a separate residence from the victim. You are not to return to the scene of the offense. You are not to possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. You are not to possess any weapons or firearms, and you are not to drive without a valid driver's license. All right, sir? All right, thank you, sir. Thank you for bringing that to my attention. Please state your name. Buchanan?
Buchanan.
All right, thank you. You're here on a warrant with regards to a violation of probation. I'm appointing the Office of the Public Defender to represent you. This is with regards to an underlying charge of petty theft, third conviction. And counsel, do you waive the reading of the affidavit of violation of probation?
Yes, Your Honor.
All right, thank you.
Go ahead, Hamilton.
Sorry?
John Hamilton.
All right, thank you. Sir, you are here on a violation of probation warrant. This is with regards, I'm appointing the Office of the Public Defender to represent you. And counsel, do you waive the reading of the warrant?
Yes, Your Honor.
All right, sir. And that warrant is set at a no bond status. You understand what I've said? All right, thank you, sir. Please state your name.
Michael Crawl.
And sir, you're here with regards to a warrant on a violation of probation with regards to an underlying charge of battery on a law enforcement officer, firefighter, or EMS. I'm appointing the Office of the Public Defender to represent you. And bond has been set at a no bond status. I believe he has a question, counsel?
Yes, there was a.
He said it's a battery on a uniformed officer.
Okay,
Law.
all right. I appreciate the clarification, sir. And you are represented by the Office of the Public Defender. And counsel, do you waive the reading of the affidavit?
Yes.
All right, thank you. Please state your name, sir.
Jason Thompson.
I'm so sorry. Please repeat that.
Jason Thompson.
You're here on a couple of matters. First is a warrant with regards to violation of probation, a charge of petty theft underlying that. I'm appointing the Office of the Public Defender to represent you on all of your matters at this time. Bond on that matter is set at a no bond status. Counsel, do you waive the reading of the affidavit?
Yes, Your Honor.
Then you're also here on a matter of a charge of
I didn't see that.
grand theft, third degree. I've read the charging affidavit, find probable cause, bond on that is set at $500. Anything else, State Defense?
Your Honor, I ask for no return.
I'm going to require that you not return to the place where this incident occurred, which is the Vineland Outlets at 8200 Vineland Avenue. All right. Anything else, State Defense?
No,
Nothing
Your
from the
Honor.
state.
All right, thank you. Thank you, sir. Please state your name.
Cuevas, Washington.
Sir, you're here on a warrant with regards to a violation of community control, an underlying charge of violation of probation, shooting at or within or into a building. The judge has set that at a no bond status, and I am appointing the Office of the Public Defender to represent you. All right, anything else, State Defense?
Nothing from the state.
Nothing from defense, Your Honor.
You waived, I'm sorry, Defense, do you waive the reading of the affidavit?
Yes, Your Honor.
All right, thank you. Thank you, sir.
Your Honor, Ms. Woods' refusal.
All right, thank you. And so with regards to the case of Willie Woods, I'm appointing the Office